Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Michegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends, and Happy New Year. It's 2025. It's 2025, and we're here again. We're here again with some new filings on the Karen Reed case, the re-persecution of Karen Reed, because it wouldn't be a new year unless we had something to talk about, right? And of course, I think this was filed actually it's actually date stamped today. It is date stamped today. Has anybody seen it? I don't know if it's been posted anywhere. I don't know what the story is. You curious about it? 227 happened, says James. Where's the SJC? I'd like to know that too. They haven't come out yet with their actual decision. So we're still waiting. The talking heads used to say. Hank Brennan's regret. Thanks for the 50. Happy New Year. Let's get this party started. Let's get it started. Well, seems that the Commonwealth is afraid of not only Dr. Russell, but Richard Green. It makes you think. Kind of makes you think, right? Because why aren't they more focused on actually prosecuting Karen Reed and proving that Officer John O'Keefe was struck by a vehicle instead of trying to disprove that Jennifer McCabe did anything wrong or that Chloe did anything wrong, right? Isn't that kind of an odd focus? Yeah. But I think what would surprise us at this point would be if there wasn't anything to surprise us about anymore in the Karen Reed case, because every day is a new day. Every day is a new motion. And every day they're giving us just a little bit of insight about what they seem to be, the Commonwealth, seem to be focused on and afraid of and don't want to come in at the second trial. And today, they want to exclude a portion of Richard Green's testimony, which is interesting. Just a portion. Just the portion that has to do with Jennifer McCabe. And Jennifer McCabe's 227, Haas Long to die in cold search, and Jennifer McCabe's deleted Google searches. Well, in one part of the motion, it says Google searches. And in another part of the motion, it says all deleted data from her phone. So it's not really clear what they're trying to exclude, but they want another Daubert hearing, and this time they want it on Richard Green. And so let's take a look at the papers. But Olivia may be joining us to help break it down, which would be great. Olivia's our resident technology wizard. She's wicked smart. You know who she is. Olivia Lambo on Twitter. If you don't know, go follow her there. Let's just say hi to some new members. Hello, Jen is a new member. Tracy is a new member. Look at Joseph Kane coming in here and gifting 2 memberships. Thank you so much, Joseph. And to those who are randomly gifted, you're amazing. Thank you. Welcome. Buzzing for Truth. Thanks for hanging around with me for 11 months. And says, You were fabulous on the Glare Show. Thank you. We had a really fun New Year's Eve stream. I think I hung out for a couple of hours, including the countdown, until the end. I was there till about 2 a.m. and we had a really good time. And a lot of you had a really good time. There were at least 2,000 people in there at all times. He did a 12-hour stream, which was a fundraiser to raise money for the defense of Karen Reed and for also Aidan Carney. And I think the final numbers on what you guys raised for Karen Reed was somewhere close to $13,000. And that was really amazing. So thank you. Thank you for watching. A lot of people were really happy. They said it was the best New Year's Eve they ever had. So that's awesome. Cat's Meow, thank you for gifting 5 memberships. Cat's Meow 420. Thank you very, very, very much. Appreciate you. Hi, Cubert. Thanks for the 5. Sent the link to all of our local yokels. Attorney Mel. And as always, I thank you for going over these court papers. Many of us don't understand. Oh, don't worry. We're going to talk about it, Cubert. We're going to talk about it. And I think it's really interesting. Sarah, be creative, dance to the music, sing a simple song. Thank you so much for being with me for 5 months. Mike Baker gifted 5 memberships. Thank you, Mike. We're bumping up on 75,000 subscribers. I would love to get to 100 because I really would love that silver YouTube play button behind me. That would be really cool. So, if you'd like to hit the subscribe button, it's free. It's totally free. Thanks, Mike, for gifting 5 memberships. Also, make sure you smash the like button on your way in. Neen Mock has been here for 4 months. Thank you so much. Mrs. Bucket, thank you for your super sticker. Justin Green for your Cash App on the way in. His New Year's resolution is to watch more of my shows. So thank you, Justin. On top is always on top of the super stickers. Shannon also became a new member. You guys are so you're so ducking amazing. You're so ducking amazing. Just giving a little chance for some more people to come in. The other thing I wanted to do, if we have time, if you're interested, is to go back and rewatch Richard Green's testimony to see exactly what they're talking about. And also so that we can see what they do not seem to have a problem with him allowing in. And also so that we can see when objections went to sidebar and what perhaps they talked about during those sidebars. Because that is also going to give us a clue into some things that the defense might be making motions about. Because so far, we've only seen Commonwealth motions recently. Happy New Year, Izzy. Happy New Year, Elf. You guys are awesome being here for so long. And Lori says, goodbye, Judge Judy. Hello. Oh, are you watching Judge Judy? Oh, I don't want to interrupt Judge Judy. Thanks for the 10, Lori, and for tuning in from Canada. Appreciate you. Mucho. All right. Everybody ready? Are you ready? I can't do as good a voice as Nurse Kim did with her new microphone and her ASMR tone, which I thought was amazing. All right. Well, it seems like Hank Brennan and/or whoever drafts his motions has been watching us, because Mark Petero and I have been saying that it is called Bates stamp, not Bates stamp, for quite some time. And he finally has picked up on that. And now he says Bates stamp. And this is filing number 447. That's right. We're into the 400s on the filings here. 447 in the Commonwealth versus Karen Reed. Commonwealth's Notice of Discovery 54. Now comes the Commonwealth in the above captioned matter and indicates that of this date, and that was just today at 8:30 a.m., the following discovery and materials have been provided to the defendant through defense counsel. Number 1, copy of digital forensic report by Ian Whiffen, 40 pages, dated December of 2024. And look, Bates stamp is now proper with the S at the end. Doesn't say what day in December, but it's a new report by Ian Whiffen. They hired Ian Whiffen, your Commonwealth, your county of Norfolk, has once again paid Ian Whiffen some sum of money to draft and research a 40-page supplemental report regarding Jennifer McCabe's 2:27 a.m. Hoslong to dying cold search. That's right, friends. That's right. That's what they're doing. The defense of Jennifer McCabe has just begun for this trial anyway. Retrial, re-persecution. And number 2, interesting here, copy of an anonymous letter to ADA McLaughlin. That's Laura McLaughlin, right? It's Laura. 6 pages. Doesn't say who sent it, when it was received, doesn't have a date on it. Don't know why somebody would write an anonymous letter to ADA McLaughlin. Your guess is as good as mine, because what we get when we get the court filings, we don't get any of the exhibits attached to it. We just get the main page, which is this page. Anything out there in the cesspool of Twitter that would indicate to anybody what that anonymous letter to ADA McLaughlin could be? No, it probably, John Monaco, probably wouldn't be admitted as evidence. But again, remember, Hank Brennan told everybody that he's going to turn over everything. He's going to turn over everything, whether it's relevant or not, whether it's admissible or not. He's going to turn over everything. So really, this is just a discovery exchange. This doesn't mean that it's going to be admitted, allowed, or in any way evidentiary. They're just turning over everything. I wonder if it's from a juror. I don't know. I really have no idea what it's about. A chain letter. A chain letter. Could be. Well, it doesn't, we don't have to really talk about its trustworthiness right now, Jen, and that's a great point. Because just because they're exchanging it with the other side doesn't mean it will ever see the light of day inside of a courtroom as part of the trial, as an exhibit, or is evidentiary in any way whatsoever. Maybe it's an amicus brief by Pleasure. It's very funny. Very funny, Christopher. I see what you did there. Very funny. Happy New Year, Nancy Kelly. Thank you so much for your super chat. Max, Happy New Year to you too. Thanks for the 5. Carpe diem is right. Carpe diem. I'm just a girl in the world wishing you all the best in the new year as well. My little friend you're from Ireland as well. Thank you for the 10. And Happy New Year to you. And also, eFlow became a member. So hi, eFlow, and thanks for joining. Okay. As docket number 448, which for some reason I have to unshare this and then share it again because, StreamYard, even though they doubled their prices, they're still not as user-friendly as I would like them to be. Okay. Come on, man. This is the motion. This is the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions. Just even the title of it alone is kind of laughable. Because what? Because you hired Ian Whiffen to write a new 40-page report that allegedly debunks Richard Green's opinions, and therefore he should not be permitted to testify. It's called Battle of the Experts for a reason, my friends. How much money are they going to spend defending the Alberts and the McCabe's instead of trying to prove that John O'Keefe was hit by a car? I don't know, but this is just another way to paper the defense, make them spend more money. If the judge allows another Daubert Lanigan hearing, I don't remember where Richard Green was from. Does anybody know? Whether he's got to fly in, whether they got to bring him in, but we're coming back next Tuesday for the continuation of the Daubert hearing on Dr. Marie Russell. So, yes, Olivia, isn't debunk something the jury does? Yes, that's why the jury is there. The jury is the finder of fact. That's right. And if the Commonwealth were so interested in debunking, why did they last minute cancel the evidentiary hearing on this very matter? Such a great point. Such a great point. The Commonwealth respectfully moves this honorable court to exclude the proposed expert testimony of Richard Green relative to 2 issues. Number 1, the claim that Jennifer McCabe's phone Googled, and then in parentheses, in quotes, it says, how long T-I die in CIKD, end quote, or, quote, Haslong to die in cold, end quote, at any time prior to 6:23 a.m. on January 29th, 2022. And 2, that Jennifer McCabe's phone incurred user deletions of any data related to Google searches, okay? Put a pin in that because you can see right here in the first paragraph, they say any data related to Google searches. But in the end, they're going to ask for different relief. So no big shocker there that it would contradict itself, but put a pin in it. Exclusion is appropriate because both claims lack any evidentiary support and the claims cannot be made in good faith. Allowing introduction of baseless claims without any scientific, forensic, or factual support would be misleading to the jury and disruptive to the interest of justice. Remember the phrases that I have underlined in red here, because what I find would be so interesting is if and when perhaps the defense would use their own words against them in future motions. Right? Exclusion is appropriate because both claims lack any evidentiary support and the claims cannot be made in good faith. How many things did the Commonwealth introduce into evidence during the first trial that lacked any evidentiary support and were made in bad faith? I can think of so many, and I'm sure that you can too. All they need to do is cut and paste this motion. Allowing introduction of baseless claims without any scientific, forensic, or factual support would be misleading to the jury and disruptive to the interests of justice. Oh, you mean like the screenshot that Ali McCabe handed over and brought with her to court that was admitted into evidence that had zero foundation? Literally the inverted, doctored Sally Port video. All of it. She says all of it. How about Higgins' text messages that he selectively cherry-picked from the extraction of his own phone and brought printed copies in when he came in to talk to the MSP to give his statement? All that stuff was let in at trial, right? Going back to the document, the Commonwealth's expert, Ian Whiffen, is a Celebrite senior digital intelligence expert and an expert in digital forensics. Okay, apparently he still works there. We had questions about whether he still worked there because he did launch his own app that his testimony in the first trial was like a very long infomercial for that app of his. So I guess he's still working for Celebrite. And then pay attention here to footnote number 1, which says, Celebrite is the leading forensic data extraction software tool that provides forensic examiners the ability to access and analyze data stored within a digital device. The Celebrite software allows an examiner to parse layers of data through different methods of extraction and analysis. So here they are telling you in footnote number 1, the Commonwealth, Celebrite is the gold standard, except for when Celebrite is applied to any of the Alberts or McCabe's phones or Ali McCabe's, and then it's not accurate. Every single defendant in Massachusetts should right now be clanging on the jailhouse doors to get out if they were in any way convicted based on Celebrite data, because you're going to see they're going to turn their opinion around. It's wild. This is wild, but makes for an interesting whatever day it is today, Thursday, January 2nd. Back to the document. He, Ian Whiffen, has engaged in a comprehensive analysis of the 2 above claims lodged by Mr. Green. His analysis has included the implementation of forensic data science, personally reviewing the device data, properly and accurately employing Celebrite technology, and a study of materials generated from the device. Footnote 2. Ian Whiffen report dated December 2024, attached as Exhibit 1, which is 40 pages long. After a comprehensive study of the forensic data and consideration of Mr. Green's claims, Mr. Whiffin's opinions disproving Mr. Green's claims are unequivocal. Mr. Whiffin provides, quote, I can state with absolute certainty that there is no evidence whatsoever on this device that the Google searches Hos long T die in CIKD or Hos long to die in cold occurred prior to 6:23 a.m. on the 29th of January 2022. Emphasis provided. Ipsy Dixit, my friends. Ipsy Dixit. Our favorite Latin term, because he said so. Ipsy Dixit. Moreover, Mr. Whiffin concluded that there is, quote, no evidence that the user tried to delete any search history or that tampering occurred with any of the data I examined, end quote. Consequently, Mr. Green's testimony on these two issues is wrong, factually unsupported, and should not be admitted at the jury trial in this matter. I need a chiropractor to come here and just crack my neck, because this is why, my friends, experts are hired to give opinions. It is what we call an expert opinion. Okay? This is like laughable, this motion. Hey, judge, we had Ian Whiffin do another 40-page report that we paid him to do, and he says Richard Green is wrong, and therefore you should not let Richard Green testify because Richard Green is wrong, according to Ian Whiffin. Experts are hired to give opinions. That's why it's often called a battle of the experts in many cases. The underpinnings of Mr. Green's testimony on these two issues fails to meet the requirements set forth in Daubert and Lanigan. Because one, the defendant cannot meet its burden to demonstrate that Mr. Green is qualified to testify on these two opinions. Number two, Mr. Green's opinions do not meet the minimum requirements of digital forensics and lack any scientific basis. And three, Mr. Green will be unable to provide any facts to support his previous testimony, which has been completely discredited relative to these two issues. I would love to see some Twilight Zone emojis in the chat, because we're back there. We're back. We are back in the Twilight Zone. We are back among the lunatic fringe, my friends. Here we are. I went back and watched some of Richard Green's testimony earlier before I'm trying to decide whether or not we should play it today and go over it. It's only about an hour and a half long. Richard Green has testified over 2,000 times in state and federal courts. 2,000 times. I didn't go back and watch Ian Whiffin's testimony, but does anybody recall, like with certainty, how many times Ian Whiffin has testified as an expert? Or how many times Jessica Hyde has testified? Can we have a you wrong emoji? Yes. Yes, I will allow it. Classic Clippy. You wrong. I will do that. You wrong. Thank you for your suggestion. It's amazing. Yeah. Okay. So I have to find where I left off. Hang on. Okay. Next page. Procedural history. On June 21st of 2024, Mr. Green testified on behalf of the defense. Mr. Green purported to be a forensic expert specializing in computer cloud surveillance systems and other systems. Mr. Green testified that he was asked to parse through data from phones belonging to Jennifer McCabe, Karen Reed, and John O'Keefe. He said the Google search was found in a write-ahead log where data is stored temporarily before it is written into the main database. Mr. Green claimed, just by the nature of it, we'll find a lot of the newest artifacts in that WAL file. Mr. Green also proclaimed that the search, quote, was in a deleted state, end quote. He testified that he found a lot, in quotes, a lot of other user deleted artifacts in McCabe's data from the morning of January 29th of 2022. He did. On April 11th, 2023, Richard Green submitted an affidavit on behalf of the defendant opining that, quote, search history information obtained from Jennifer McCabe's cell phone indicates that on January 29th of 2022 at 2:27:40 a.m., the phone's user entered the following search in Safari, quote, Haas Long to die in cold. Footnote number 3, which is attached as an exhibit here, but we don't have the exhibit. It says affidavit of Richard Green in support of defendant's motion for an order pursuant to Rule 17 directed to Brian Albert, Verizon, and AT&T, which is an 8-page affidavit. I don't even know if the original motion that I have had that attached as an exhibit, so I don't think I have it. But if anybody does have it, you can email it to me for later. fanbase@mlittlelaw.com. On June 21, 2024, Mr. Green testified at the defendant's first trial and rendered a similar opinion, claiming that certain phone calls were user deleted. Footnote 4. See the June 21 trial testimony of Richard Green, 62 pages, which is attached as Exhibit 3, which we also do not have. During cross-examination, Mr. Green was broad and vague about his training, experience, and lack of digital forensic certifications. Footnote 5, Exhibit 3, page 39 to 40. I would submit to you, breaking from the document for a second, to say that if he was broad and vague, perhaps Mr. Lally should have asked more direct questions. Your failure to cross-examine properly did not later on give a basis for a motion to exclude just because now you have a newly special hired assistant district attorney that has replaced Mr. Lally. Mr. Green conceded during his trial testimony that Cellebrite modified their software based on his misinterpretation of data from Jennifer McCabe's cell phone. What? I'm sorry, what? I'm sorry. Did you just say in your moving papers that Mr. Green said that Cellebrite modified their software because of something that he did based on his misinterpretation of data from Jennifer McCabe's cell phone? Because of that, Cellebrite modified their software? What? Okay. Do you want to talk about baseless claims? I think that's like one of them. Despite knowledge of his error, Mr. Green has yet to submit a revised written report or opinion. Guess what? It's not their turn yet. It's not their turn yet. We've been over this 100 times, but I'm going to say it a little bit louder for those out there who don't understand it. And it's none of you, because I know all of you that are watching me understand it, except for maybe the 20 hate watchers. And hey, hate watchers, hit the like button on your way out. No, I just lost my train of thought. Hold on. It's coming to me. Under Rule 14, which is the automatic disclosure statement rule, automatic disclosure rule in Massachusetts, the prosecution is required to automatically disclose all of their information and evidence and expert information to the defense. When they are done turning over everything, they file a certificate of compliance. And then, and only then, does the time start to run from which the defense must turn over all of its automatic disclosure to the prosecution. Those aren't my rules. Those are the criminal rules of procedure in Massachusetts. In response to Mr. Green's misconstructions, the Commonwealth retained 2 experts in digital forensics, Jessica Hyde and Ian Whiffen. During the defendant's first trial, the court permitted a courtroom demonstration by Mr. Whiffen to assist the jury in understanding digital forensics and how the Google searches were stored within the digital databases, specifically the Safari internet browser. Additionally, Jessica Hyde, a highly qualified forensic examiner, conducted an encompassing review of digital artifacts, file systems, and conducted independent peer-reviewed experiments to determine that Jennifer McCabe's phone was in use at 2:27 a.m. when the Safari browser was open and looking at a website for Hockamock Sports. At 6:23 a.m., the same Safari browser tab was engaged in a new search for, quote, how long, end quote, was conducted when, quote, Apple produces a suggestion for how long to digest food. The search is instead completed with how long TI die in CKLD at 6:23 a.m. A new search is conducted at 6:24 a.m. of how long to die in cold, end quote. This finding was consistent with Trooper Garino's review of the cell phone extraction and with testimony of other witnesses. Argument. I'm parched. Hold on a second. Look at Clinton coming in with a 5 and another 5 and then another 5 to ask a question. Thanks for the 15, Clinton, who says or asks, I forget, is Green from Celebrite as well? No, he is not. He has his own independent forensics company, but he has over 28 years of experience and he's testified as an expert over 2,000 times. By the way, this something happened on my birthday, so maybe that's why I'm so invested. Happy birthday. Happy birthday, Clinton. Happy and healthy new year to Dr. Russell is my hero for tuning in from Norway. Happy and healthy new year to you too, my dear. And thank you for the super chat. Argument. Richard Green's debunked opinions. Okay, debunked opinions. Again, their opinions. The jury is the finder of fact here. That's what a jury does. Jury weighs the evidence and they decide what's debunked and what's not. But Hank Brennan wants the court to believe that Richard Green's opinions have been debunked and says they are not an example of a, quote, battle of the experts, end quote, best left to be resolved by the fact finder, but instead an attempt to infect the jury with an inadmissible opinion that is not premised on reliable digital forensics. Oh, hi, Microdots. Microdots is here. Hope you're prepping something on this because this is wild. Celebrite has updated its software to prevent manipulation of data. Shortly before the defendant's first trial, Celebrite created and introduced Physical Analyzer Software version 10.2. Since the defendant's first trial, Celebrite has added another version of updated software, 7.67. The updated version removed the timestamp value from records sourced from the Safari's database from the Safari's browser state.db, because further research shows that the timestamp is not a reliable source for a timestamp relating to the URL shown. Well, hello, every defendant, not even only in Massachusetts. Hank Brennan has just told every prisoner who's locked up, I don't know if you guys get YouTube in prison, but if you're locked up based on the timestamp on a Google search and the Celebrite extraction, You now have a get out of jail free card, pretty much, because it's not accurate. Because he's telling you guys that Celebrite was wrong all along until after Karen Reed's first trial, when they now all of a sudden have removed that timestamp. Everyone locked up because of this needs to go free. That's right, Holly Ann Crow. Bentley says they really don't care if they're potentially blowing up other cases. Nope, they don't. I'd love to know this too. If the Commonwealth is so confident in their case against Karen, then why do they spend so much time and money, I'm going to add, trying to debunk and discredit Richard Green and Dr. Russell? And next will be, I'm sure, the crash daddies, the ARCA experts. And then he or she goes on to say, the Commonwealth is so embarrassing. Right, Olivia. Or if you got convicted with Celebrite showing you destroyed or deleted evidence, you should also be getting out of jail now. And perhaps you should hire Hank Brennan to defend you because he's the one who's telling you this. The basis for Mr. Green's contested opinions has been refuted not only by the Commonwealth's independent experts, but by Celebrite itself, who has removed the type of timestamp relied on by Mr. Green from Celebrite's decoding engine. Where's the affidavit from someone at Celebrite saying that? Are you saying that Ian Whiffen is now a spokesperson for Celebrite? And so his new 40-page report is the absolute 100%. He's speaking now for Celebrite. Is Celebrite listening? Hey, Celebrite, if you're listening. I mean, I don't know you personally, and I've got no stock in your company, but is it a public company? I'm interested. Is your stock price going to now tank because of this? Because unless they're saying, and there's no affidavit, by the way, by Ian Whiffen attached to this. It's not an affidavit, it's a report, which is not sworn to under the pains and penalties of perjury. But he says right here, it's been refuted by Celebrite itself. Okay, where's the evidence of that? Nothing to see here. Just take my word for it. Look the other way. Further, when Jennifer McCabe's cell phone extraction is analyzed in the newest version of Celebrite, the 2:27 a.m. last visited timestamp no longer appears on the extraction report. Rather, the time shown represents the status of the browser tab and digital forensic artifacts pertaining to web history, and Apple Mobile Safari again confirm that the Haas Long to Die in Cold search occurred at approximately 6:24 a.m. Well, how does it prove it if the timestamp no longer appears? I'm not a techie. That's why I rely on Olivia for these things. But apparently they've revised their entire software program because of Richard Green and Jennifer McCabe. Well, thank you, Lisa. CLBT is their NASDAQ sign. Anybody want to look up the current stock price and we'll just track it from here on out? Thank you, Lisa Graham. Lana Del Turtle says it seems to Brennan, seems to me, she probably means to say, Brennan really doesn't have the right stuff. But we know what they're afraid of. But who's strong-arming them to spend all of this time, money, and effort on defending Jennifer McCabe's 227 search? Because it has nothing to do with whether or not the evidence shows Officer John O'Keefe was struck by a vehicle. Really, when it comes right down to it. I mean, would it show consciousness of guilt on behalf of Jennifer McCabe's phone? Maybe. But it still doesn't prove that John O'Keefe was hit by a vehicle at 24 miles an hour going 62 feet in reverse or 60 feet in reverse, whatever the hell it is now. Keeps changing. Okay, it's $21.64 today. Thank you, Brian B. Celebrate. See if the astroturfers get out there and start trying to stock the tank. Start trying to tank the stock price. It's down already 1.82%. Might be a good time to buy. Keep watching. Likewise, there was no evidence that the Google searches were user deleted. Footnote number 7. See Jessica Hyde Digital Forensic Analysis Report, page 4, as Exhibit 4, which was provided to the defense in discovery notice number 53 on December 20th of 2024. Oh, and then Bates is properly spelled, so that's good. But what they did was, not only did they hire Ian Whiffen to come back and write a new 40-page report, they hired Jessica Hyde also, because we did go over that notice of discovery number 53 on December 20th, which is another 4-page report by Jessica Hyde. Even though Mr. Green's claims are wrong, the defendant herself has engaged in promoting this false narrative. Can we get any further afield here? In a June 20th, 2023 interview with Gretchen Voss, the defendant advanced this baseless claim. Karen Reed, first court appearance after we received that Jen McCabe, Ms. Little, not me, but Eliza Little, no relation, Googled Mr. Yannetti. Yeah, defendant, which, for just sake of keeping this clear, just you could write Karen Reed again, but, looks like 4 different, whatever. And it happened at the same time as the basketball search, which also wasn't in the report, nor was the how long to die at 6:23 that she admitted to. There was no Google activity in the Celebrate report that was handed over to us as gospel. And there's something that's redacted, and it is footnote number 8. See transcript of June 20, 2023, interview of Karen Reed by Gretchen Voss. They don't say it here, but that was in Boston Magazine, and they don't attach it for the court. It does not attach. So should the judge just Google it? Try and find it? Inadmissible evidence should always be excluded. I'm going to repeat that. Inadmissible evidence should always be excluded. I loved that sentence so much that I put a big red arrow there. Mr. Brennan, didn't you say in your motion papers on January 2nd that inadmissible evidence should always be excluded? Wouldn't you agree, Mr. Brennan, that Allie McCabe's screenshot from God knows where, God knows when she screenshotted, who she sent it to, if it's accurate, why there's no date at the top, whether it's real, whether it's fake, should always be excluded. How about that inverted Sally Port video? Wouldn't that be inadmissible? Screenshots, yeah. How about the cherry-picked, self-printed up text messages of Higgy? How about that on inadmissible evidence? Inadmissible evidence should always be excluded. I'm so glad you agree, Mr. President. I'm so glad. Allowing debunked claims to reach the jury would necessarily risk misleading the jury and creating prejudice to the Commonwealth. Creating prejudice to the Commonwealth. Because you know what they don't give a duck about in Massachusetts, in my opinion, is the defendant getting a fair trial. That's not important. We don't care about that. What we care about is prejudice to the Commonwealth, who has a bigger bank account, unlimited resources. Let's not prejudice them. Let's try and bankrupt the defendant times 2 and her parents. Let's do that. How about all of the evidence that had 0 chain of custody? How about all of that evidence? How about the fruits of the poisonous tree? If Karen Reed's cell phone was seized without a warrant to seize it. How about the vehicle data? How about the entire vehicle and anything having to do with the vehicle, fruits of the poisonous tree, if that vehicle was seized without a warrant to seize it? I mean, we saw some search warrants somewhere that we went over recently where Michael Proctor swore under the pains and penalties of perjury, by the way, in his affidavit to obtain that search warrant. Now, that's to search the vehicle and the phone, wherein he lied several times and said that they were seized around 5:30 p.m., which we know is untrue. They were seized at least an hour earlier, maybe even longer. How about all that stuff? I'm just saying. Citing a case called Commonwealth v. Hines, they quote, "The role of expert testimony is to assist jurors in interpreting evidence that lies outside their common experience," end quote. Mr. Green's factually wrong opinions would not assist jurors and would instead risk confusing jurors. No. That's why it's a question of fact for a jury. In fact, you should be so confident in your cross-examination that you should be able to debunk everything that he says in court, on the stand, in front of the jury, the way it's supposed to be. But, that's just my opinion. Law. An expert witness is not permitted to testify to matters beyond an area of expertise or competence. Citing that Rentala case again that we went over one day about the paint drying expert. The Commonwealth asserts that Mr. Green is not qualified to render an opinion claiming, 1, Jennifer McCabe's phone Googled how long tea die in sicked or how long to die in cold at any time prior to 6:23 a.m. on January 29th of 2022. And number 2, any claim that Jennifer McCabe's phone incurred user deletions of any data. See here, it says any data. But in the first paragraph, they just were referring to Google searches. But now, any data, because remember how many phone calls she deleted, allegedly? Text messages, screenshots, and Google searches. So which is it? A Dalbert Lanigan hearing is necessary to assess whether the defendant may call Mr. Green to testify to these 2 debunked claims in her second trial. But notice, put a pin in this as well. The only parts of his testimony that they want excluded, they don't want him excluded as a witness altogether. They only want him excluded with regard to these 2 specific points regarding Jennifer McCabe's phone. Exactly, Jeff. Sneaker Arena, that's what I'm asking you. He also testified about John O'Keefe's phone and the Apple Health data contained therein and the GPS points, the going up and down stairs and things like that. They don't care. They're okay with that stuff coming in. They just don't want him to be able to testify about Jennifer McCabe. It's so interesting to me. Again, a Dalbert Lanigan hearing is necessary to assess whether the defendant may call Mr. Green to testify to these 2 debunked claims in her second trial. Again, it's not up to Mr. Brennan and Ian Whiffen to say what's been debunked. It's a question for the jury. It is the defendant's burden to establish that Mr. Green's testimony will assist the trier of fact to understand the evidence or to determine a fact in issue, and that the methodology or theory underlying the expert testimony is sufficiently reliable to be presented for the jury's considerations. Citing 2 more cases and quoting one of them, proponent must establish a sufficient foundation for a judge to determine whether the expert's opinion satisfies gatekeeper reliability. Clearly, The methodology or theory underlying Mr. Green's testimony is not sufficiently reliable to be presented for the jury's consideration. A jury should not be permitted to consider baseless claims. Well, hang on, I'm just going to break for a second to say the baseless claim here is that John O'Keefe was hit and killed by a vehicle, any vehicle. That's the baseless claim here. You know what's even crazier? Is that the Canton police report with regard to the murder of a Boston police officer was 8 pages long, and the Canton police report investigating Richard Schiffer's alleged witness intimidation, rubber ducks, and littering around town was a 36-page report. The defense will not be able to meet the Daubert-Lanigan standard required to proffer Mr. Green as the two contested opinions. Conclusion. For the foregoing reasons, the Commonwealth respectfully requests that the court order a Lanigan hearing or exclude Mr. Green's opinions relative to the two contested claims at trial. XOXO. Specially appointed district attorney, Hank Brennan. Adam Lally got his name on this one too, as did Laura McLaughlin, assistant district attorney. It was dated New Year's Eve, but it wasn't filed with the court until today. So there's that. Let's go to the chat. Happy New Year to you too, Jen, for being here for 5 months. It's okay. It's okay that you're late. We're not gonna penalize you. Thank you. It doesn't mention these people have degrees for tuning in from Canada for your 5. Serious question. Who can stop all the Commonwealth shenanigans? What can be done? This motion and all the others are absurd. They are defending Jennifer McCabe. It's true. Shenanigans, tomfoolery, and ballyhoo. All the things. Thank you for your super chat. Kristen became a new member. Kristen S. We have a lot of Kristens here. Thank you. Midnight Mike gifted a membership. Thanks, Mike. And also Joseph Kane came in and gifted another membership. Thank you, Joseph. In fact, I was in someone's chat, Auntie Deb's chat the other night when you gifted me a membership. So thank you. I know how generous you are on everybody's channel. And we all appreciate you very, very much. Dr. Russell is my hero, comes in with another super chat. So he is qualified enough to make Celebrite modify their software. But not qualified enough to testify in the trial. Yep. Interesting, right? Shield and sword. You can't use it as a shield and a sword. I always say that. Excellent, excellent point. I love this. You guys are the most intelligent chat on the YouTube. Snarky, funny, and you get it. Hi, Mama She. Thanks for the 10. Didn't Vanity Fair have an expert that said it happened at 227 also? Yep, they did. They did. Didn't the feds too? I don't recall, but I think they might have. Scott McGinnis, thanks for hanging in here for 8 months. Brenny Whitey's lawyer plus Marcy buds with Billy. Billy Tibbetts? Billy, which Billy? Thanks, Scott. Sarah B. Creative, thanks for the 10. I usually write a music quote, not today. Whiskey is for drinking, water is for fighting over. Mark Twain. Excellent. Thank you, Sarah. Love Shack's been here for 10 months. 11 months. Another pearl clutching motion. Embarrassing. Sweet Lou, thanks for becoming a member. And look at this. Hank Brennan's regret coming in with another 50. Thank you so very much. Surely Auntie Bev can clearly see that this could have serious ramifications to other cases that have used cell data to convict others. This is very dangerous if she allows this. Hank is spinning wheels to defend the McDowells. This is crazy. It is. It is crazy. It is wild. I've never seen anything like it. I've never seen any state go to such lengths and expense and time to defend a non-party witness. It's wild. It's wild. I mean, help me understand. Thank you, Hank Brennan's regret again. Laura, hi, Laura. Thanks for the vibe. Melanie, you got no quit. From New Year's Eve with the glare to today. He was up to date. Bless you too. Thanks, Laura. Doesn't mention these people have degrees. Why is Jen McCabe being proctored? Who does she know or what does she know? Great question from coming in from Canada. You know why? Because the world is watching. The world is watching. And that's exactly what I think when I read this. Why don't we want to let a jury decide? Why are we spending so much time and money to protect Jennifer McCabe? I don't get it. I don't know. If anyone, who, ambulance driver for the 5, thank you. They can't even prove the 623 and 624 searches with camera footage, right? Jennifer McCabe, in one of her many statements, said that they were saying the Our Father together in the backseat of a cruiser when they were holding hands. And that's when Karen, she says, told her to Google, how long does it take to die from hypothermia? Or something like that. Haven't seen that dash cam footage, have you? Nope. Christine Mitchell, thanks for coming in. Melanie, when do you think we will hear from the SJC? I don't know. We've seen other decisions drop since they've been on break. If that decision's not in by the time we get to April 1st, they're going to have to postpone the trial again. So I don't know. My crystal ball is broken, Christine. Your guess is as good as mine, but I do know that one decision that we went over in which the SJC, the same panel that heard Karen's arguments, in their decision, they increased First Amendment protection rights for people of Massachusetts, and they also, on their own, just decided to modify some jury instructions. So we know they're not afraid to make new law. That case was heard about a month before Karen's. So I don't know. Cynthia Lynch, thank you for your super sticker. Olivia, did you want to come in? You have some things to say? See if Olivia can get to a phone so she can call in. What say you? Kat says, I wonder if she flipped on the Alberts and now they're just trying to keep her out of it. I don't know. Tucker dude, what sort of notice will we get when the SJC makes a decision? Well, you'll get my notification that I'm going live to tell you about it. That's the notice. That's the notice that you're going to get. It'll probably be reported in all the local papers, just like this has already been reported in today's. Let me see what this is. CVB already has an article up. And this is from earlier this morning, 10:41 a.m. Karen Reed, prosecutors want testimony about Jennifer McCabe's cell phone excluded from the second trial. Take a look at this quickly. You think it'll drop next week? It may. Man, that font is small. Hang on. I'll help you out here. In Boston, prosecutors in the case of Karen Reed are asking the judge to exclude testimony about cell phone data from her retrial, which is scheduled to begin later this year. Reed, 44, of Mansfield, is accused of hitting her boyfriend, Boston police officer John O'Keefe, with her SUV outside of Canton, Massachusetts home on January 29, 2022, and leaving him to die in a snowstorm following a night of drinking at C.F. McCarthy's and Waterfall Bar and Grill. In a motion filed on Tuesday, the state wants the proposed testimony of Richard Green, the founder of United States Forensics, to be barred from Reed's new trial. Well, that's not exactly true. They just want two things in his testimony to be precluded. Green previously testified about his analysis of cell phones belonging to Reed, O'Keefe, and friend Jen McCabe. He testified that McCabe's phone was used to Google search Hosselong to dying cold at 2:27 a.m. The state wants the alleged Google search and testimony about any deletion of data from Jen McCabe's phone to be excluded. Quote, exclusion is appropriate because both claims lack any evidentiary support and the claims cannot be made in good faith, the motion read. Allowing introduction of baseless claims without any scientific, forensic, or factual support would be misleading to a jury and disruptive to the interest of justice. What about Trooper Paul's testimony? What about that? Would anybody argue? Anybody want to make a motion? Because apparently in Massachusetts, anybody can make a motion and have it granted, such as we saw in Aiden Carney's case last week, where what we would call an alleged victim, but what the judge called the actual victim, made a motion to impound some things, and you can just make a motion and have it granted because the judge granted it. Allowing introduction of baseless claims without any scientific, forensic, or factual support would be misleading to the jury and disruptive to the interest of justice. Well, maybe Trooper Paul should be excluded too then. Right? Prosecutors are trying to show that Reed's alleged actions outside 34 Fairview Road were intentional. Reed's lawyers have alleged that there was a cover-up involving members of several law enforcement agencies. Well, not really. Not everyone's a law enforcement agent. They say O'Keefe was beaten by someone else inside the home, bitten by a dog, and then left outside. Reed's first trial ended July 1st with a hung jury, and she's attempting to convince the Supreme Judicial Court to drop some charges while she awaits a second trial. Well, yeah, that's because like most of the jury came back and said they acquitted on counts 1 and 3, but they don't say that. Prosecutors have also asked the judge to bar Dr. Marie Russell, a retired emergency room doctor and medical director for a prison in California who testified for the defense in Reed's first trial. Quote, I believe these injuries were sustained by an animal, possibly a large dog, because of the pattern of the injuries, she testified. Russell cited parallel marks on the upper part of O'Keefe's arm that she opined were inflicted by either teeth or claws. Reed's defense contends O'Keefe was dragged outside after he was beaten up in the basement and bitten. This just jumped on me. By a dog at fellow Boston officer Brian Albert's home in Canton. The Commonwealth argues Reed's defense team failed to prove Russell was an expert in canine bites and claw marks. The judge has not issued a decision about Russell's testimony. Well, that's because we still have to go back for part 2 of the Daubert hearing on Tuesday, January 7th, next Tuesday. Set your calendar. Prosecutors suffered several notable setbacks during their presentation of the first trial, including embarrassing revelations about the very regrettable messages sent by a Massachusetts State Police trooper assigned to the case. That trooper was later suspended, and other officers have faced internal affairs investigations. Why don't they name him? Why don't they say Michael Proctor? Who is this WCVB? In the wake of the first trial, attorneys in this case and others have debated whether Proctor's email and text message records can be reviewed as evidence by the defense. Well, they name him there. Okay, weird. Reed's defense also tried to raise questions about how and when her SUV became damaged, including questioning surveillance video from a police garage that appeared to be inverted. Reed's second trial is scheduled to begin on none other than April Fool's Day, April 1st. So there's that from WCVB Channel 5 as of early this morning. What say I say, I vote for. All in favor say aye. Who wants to rewatch Richard Green's testimony? All in favor say aye. It's only been an hour. WCVB John Monagle says equals Greg Henning equals Brian Albert's attorney. Interesting. Charlie Lynn says exclude Trooper Reno. He actually is debunked. Thanks, Charlie Lynn, for hanging around for 8 months. Yeah, regrettable. That's what they're saying. They're saying it's regrettable, his behavior. Honey Bear, thanks for coming. New member. Intolerant. CW has one. No shame. Hanks wants all the defense excluded. Yeah, they do. Hank Brennan's regret. Thanks for the 20. At this rate, why don't they just request that Karen be required to defend herself without any supporting documentation or evidence? You know, so interesting that you say that. But so many people and attorneys feel so strongly about Karen Reed's innocence that they have come on board and offered to testify, experts, right? Dr. Russell is the one who reached out to the defense. Bob Alessi, who is now a New York attorney that has become part of the defense team, has joined for free, pro bono. Maybe there's some other experts who are going to come out of the woodwork, other people who might have seen something that night, people who know something about what really went on inside 34 Fairview. Even Michael Phelps in his podcast said the men were hanging out downstairs while the women were upstairs in the kitchen. He said that was according to trial testimony, but we know that's not true. So based on the dozens of people that Michael Phelps interviewed for his podcast and the hundreds of hours of tape that he has of interviews, who told him that the men were in the basement and the women were upstairs in the kitchen? Inquiring minds want to know. I'm one of them. Alessi is so good. All right. Olivia's going to be joining shortly, but in the meantime, let's start with Richard Green's testimony, because I also want us to take special note of where the objections occur and where the sidebars occur, because the defense has made a motion, or maybe it was a joint motion, I can't recall now, to have all of the sidebars transcribed in preparation for their pretrial prep for the retrial. And when I went back and watched this, it's so interesting where the objections occur, what happens after they come back from sidebar, what's allowed in, what's not allowed in. Right? Of course, right. Okay, this happened. Let's put the closed captions on. This happened on, what day was it? June 21st, 2024. I know you guys are going to have some PTSD from this, but hang in there.
I do. Thank you. Good afternoon.
I have this on fast.
May I proceed, Your Honor?
Yes.
Sir, if you pull that microphone as close to your face as you can so your voice will be kept up, and I'd ask you to state your name and spell your last name.
Sure. Richard Green. That's Green.
And where do you live, sir?
I now reside in Coldwater, Michigan.
What do you do?
I own and operate a
That answers one of my questions. He lives in Michigan, so they're going to have to fly him in for any Daubert hearing if she so chooses to give them one.
company called United States Forensics.
And what is United States Forensics?
Sure. We're a digital investigation firm. We have we're licensed in Florida and Michigan, but we do cases across the country.
All right. And again, I'd ask you to keep your voice up only because we have a
Only because Judge Bev might decide to turn off the air conditioning if you don't speak loudly enough. Olivia's here. Hi, Olivia.
Hi.
Can you hear me?
Yeah, can you hear me?
I can. I may need to turn up your volume a little bit. Can you guys hear Olivia okay? Speak again, Olivia.
Is that better at all?
I can boost you. Hang on. Okay, try again.
Hi, everyone.
Okay, can you guys hear Olivia? Just so you can hear Olivia. Okay, is she
Mic
good? Is she
check.
at a good volume? Hi. I was just starting to watch Richard Green's testimony, but before we do that, do you have any other thoughts that you want to talk about?
Oh my gosh.
So many thoughts. Let's take him down for a second.
So many thoughts. Well, I would say for starters, if you refer back to Richard Green's affidavit where he revealed all of these findings according to Celebrite's reports, Richard Green does something that is a well-respected practice amongst experts. He employed redundancy in his testing. And so Richard Green didn't just use Celebrite to come to these findings or come to these determinations. Richard Green used, I think, to the tune of up to 4 or 5 other digital forensic software tools to find the incriminating evidence that exists on Jen McCabe's cell phone. So he not only used Celebrite, he used Axiom, he used Sanderson, he used Belkasoft, he used Cellhawk, and the Commonwealth's digital forensic expert, before they hired these third-party experts, Guarino, he didn't use all of those digital forensic tools. In fact, he avoided using, for instance, Cellhawk when he was doing his GPS analysis of John's phone. So my question is this is kind of, it's funny because it's an attack on Celebrite, an indictment on Celebrite, while at the same time claiming that indictment on Celebrite is coming from the person who's from Celebrite.
Exactly.
So
Exactly.
can we rely upon Celebrite, or can we not rely upon Celebrite? And is the Commonwealth planning on calling representatives now from all of those other forensic software companies to say that their programs are wrong, and that it's all like, that's the conspiracy theory,
Mhm.
is believing that all of these independent, objective digital forensic tools are framing Jennifer McCabe,
Right. Right.
and that they all of them happen to come to the same conclusion too. I mean, what a coincidence that would be.
Mhm.
Is it just another coincidence?
Seems like it. It seems like they're spending so much money and so much time defending this 227 search or trying to debunk it instead of spending that same time and money proving that John O'Keefe was hit by a car.
Which is crazy, because when you think about it, the Commonwealth, quote unquote, debunking
Mhm.
the 2:27 a.m. search, even if they, let's just say in a hypothetical world that they're successful at doing that, at debunking it,
Mhm.
that doesn't incriminate Karen Reed at all.
No. I
At
know.
all.
I know. I know. I just said that a few minutes ago. I'm like, okay.
So
Even if
I mean, it's
it,
it's like the sorry, go ahead.
it's like an exercise in futility. What in the end, what does it matter?
Right. Right. Well, it's I mean, it's they're literally embodying exactly what is being alleged of them. This is a cover up.
Right.
This is a cover up. Why would a cover up occur? To cover up someone's crimes, to defend them, and to hide their incriminating evidence. And the Commonwealth is employing all resources to do just that.
Exactly.
I mean, my question is, if this were an issue that the Commonwealth had a good faith belief that Richard Green, because this, with this filing, this goes beyond, oh, Richard Green is mistaken. And is it Richard Green who's mistaken, or is it Celebrite who's mistaken?
They said in their papers that they actually revised their software because of Richard Green and Jennifer McCabe. That's the reason they went back and revised their software. Did I read that wrong? I don't think so.
Right, yeah, and you read somebody's message in the chat. I love that it's like Richard Green. So Richard Green is skilled enough, qualified enough to exploit a vulnerability of your software that's used to convict people,
Mhm.
but he's not skilled and qualified enough to be an admissible expert witness.
Agreed. And in their papers, didn't they say that, so because of this, Celebrite took their timestamps off? They don't have
They
timestamps
said
anymore? I'll read it again.
about the now it just shows like the time. I think it's the data are I think the inference is that the data are now more vague, and it rather than saying it's about the tabs, basically, like the manipulation of the tabs at a certain time.
It says here, all right, wait, I'll pull it up for you just so you can explain it to everyone. Because the fact that they're saying it's because of Richard Green is kind of wild to me. The basis for Mr. Green's contested, wait, where it is? Start here. Since the defendant's first trial, Celebrite has added another version of updated software 7.67. The updated version removed the timestamp value from records sourced from the Safari's browserstate.db because, quote, further research shows that the timestamp is not a reliable source for a timestamp relating to the URL shown, end quote.
You know what I was thinking about before, like long before this filing ever came out, is the defense. I don't know if you could actually do this, but the defense ought to employ Jessica Hyde and Ian Whiffen to have them look at the entire phone extractions in this case. Have them look at Jen McCabe's entire phone extraction, have them look at John O'Keefe's entire phone extraction, and at Karen Reed's entire phone extraction. Because notice how the Commonwealth, for both of those expert witnesses, gave them a very limited, defined, narrow scope of what to look at. And they also kind of predetermined the outcome for those experts in the way that they shaped their request.
Right.
They didn't ask, is there any evidence that this search occurred at 227? Or can you confirm any and all possible times that this search occurred? Rather, they already said, we know that these searches occurred at 6:23 and 6:24 a.m. Can you confirm that?
Well, they can't hire them because there's a conflict of interest, but they could certainly cross them with it.
But
Show them the additional stuff that they weren't provided with.
Of course, yeah. And I think
Right.
that they should raise in their response, if the Commonwealth is so concerned with having reliable, accurate digital evidence in this case, or the correct interpretation of it, even though that's like literally what tools like forensic tools like Celebrite and Axiom do, is that they interpret, they parse the data, and then they're an essential part of the interpretation process. Yeah, I mean, then why not have these experts look at all of the other facts in dispute? It's not just a Google search. And
Right.
it's funny how he uses that verbiage in his filing here. In the beginning, he says he wants to preclude Richard Green from being able to testify about deleted Google searches, data pertaining to deleted Google searches. And then he seems to later become more vague about that, to include any deleted digital data from Jen McCabe's phone. But Ian
Right.
Whiffen and Jessica Hyde, they never were tasked with looking at Jen McCabe's phone call log deletions, or the text messages she deleted, or the screenshots she deleted. So you can't try and conflate all these issues and try and deceive the judge because she may be slightly ignorant to the nuance.
Agreed. In my opinion, this is another attempt to just keep draining the pot of, of Karen Reed's resources to be able to defend herself. Let's just, every time they file a motion, it's more money, more money, more money. Every time they need another hearing, they got to fly the expert in, pay the expert. They're going to need to pay him to do, a supplemental report. Now, I mean, it's just everything that they can do. And this is really not only shining a light on the ability to wrongfully persecute someone who, when there's no evidence of the crime that they're trying to prove, but also how a defendant who is not eligible for a public defender and is paying for their own defense, how they can be forced into spending tons and tons and tons of money to defend themselves effectively against a state that has unlimited resources.
Yeah, I mean, I'm sorry to say it, but the concept of right to a fair trial is kind of, I mean, certainly in this case,
Mm-hmm.
it is pretty much non-existent.
100% agree. 100% agree. Let's go back and we'll continue with the Richard Green's testimony. I just want to point out, first of all, I don't think he's the greatest witness. I do not think he's the greatest witness. I've seen far better expert witnesses. He doesn't seem very comfortable on the stand. He stutters sometimes. He doesn't seem to always understand the question. But I think part of that is that Lally's questions to me, and you can let me know what you think during cross, Lally's questions seem to be scripted and somebody wrote them for him. And I think that the questions aren't clear. And so when Richard Green tries to answer them, he's kind of like, oh, I don't even understand your question. But he was trying to be nice about it.
Yeah, I agree with you. I think that Richard Green, the thing is, the data are the data are the data at the end of the day. But I agree with you. Your expert witness's presentation on the stand is very important. That can completely change the outcome, regardless of how solid your data might be. But, and I agree with you. I think Richard Green he's got like the Southern charm. He's so polite and generous.
Yeah.
And perhaps part of it is a preparation problem, or just, I imagine, I mean, this guy's testified, you said, in 2000 plus trials.
Right.
And I got the impression that he was so kind of caught off guard by Lally's, kind of not aggressiveness, because cross-examination is always going to have a level of aggressiveness, but Lally was trying to he wasn't trying to get to the truth by the way that his questions were wording. He was trying to insinuate nefariousness from Richard Green, or ignorance
Right.
to Richard Green. And he actually did this. You'll notice in a lot of, if not most of, Lally's cross-examination of defense witnesses, Lally did this thing, and I noticed it with Lucky Loughran, when he's cross-examining Lucky Loughran, where he will ask a question that is, referring to, it's stating their prior testimony, that witness's prior testimony or prior findings or what have you. And Lally misstates the prior testimony. And it's subtle, because so for Lucky Loughran, when he does it, he's claiming, when he's cross-examining Lucky, that Lucky previously said something else as it relates to the time that he drove by, the time issues. And Lally actually was incorrect, and he kept misstating Lucky's prior testimony so as to make Lucky look like he's unreliable, he's uncredible. And the weird thing was that I don't know if the defense objected or not, but ultimately Judge Bev cut it off, which to me was like even more troubling, because it's like, does that mean that you, Judge Bev, are aware that Lally was just misstating the testimony, which you would do in a bid to deceive the jury, because there was no other obvious reason for her to, there wasn't an objection pending. And so anyway, but that's a whole other rabbit hole. But Lally tends to do that, it seems, on cross-examination. And so, yeah, I think Richard Green just wasn't quite prepared for that.
I think just because he's not a confident witness on the stand, and just because maybe he stumbles, and just because maybe he doesn't seem like the most well-spoken expert witness we've ever seen, it doesn't make him unqualified to testify. right?
Exactly. And that's precisely what the purpose of a Daubert hearing is.
Yeah.
And I mean, it's just how like ridiculous after they last year pulled that dirty move of last minute after Karen Reed had already paid and flown her expert witness, Richard Green, out here, paid for a hotel, paid for his time.
Mm-hmm.
Expert witnesses are not cheap. For a already agreed upon evidentiary hearing,
Yep.
the Commonwealth pulls that dirty move last minute. They, bombard the defense with all their oppositions in response.
Mm-hmm.
And the judge allowed that, basically canceled the evidentiary hearing
Yep.
that was scheduled for that day. That's why Richard Green was flown out there. Evidentiary hearings are where if there's a dispute in facts, that's what an evidentiary hearing is for. But the Commonwealth was desperate to avoid that from, to avoid allowing that from happening.
Right. And isn't that the decision that went up on appeal? And then they did get a portion of Jen McCabe's records and Brian Albert's records. I think that's
Yeah,
the one that went up.
It was a big part of the defense's argument in that
Mhm.
case.
Yeah. And then they eventually did get some of the records. But anyway, let's start watching this because I have a hard stop at like around 6. Hopefully we can get through this, maybe a little bit after 6. Let me know if there's any point you want to stop, and I'll just speed it up a little bit in the beginning at 1.25. And then there's some stuff I want to note where like the objections are. And there's just, every time I listen to this, it just makes me madder, but let's go.
The air conditioner there, and we have jurors behind me.
Okay, I'll
So as
do my best here.
Yeah, as best you can. Now, you are president of that company, sir?
I am.
In addition to managing the company, what do you do on a day-to-day basis?
Well, I perform the majority of the investigations. I specialize in computer, cell phone, cloud, auto video, metadata media, surveillance systems, things of that nature.
Do you work in conjunction with others?
Certainly.
Describe that, please.
Certainly. Well, we do take cases from individuals. I prefer to take cases from attorneys. We've also worked with numerous public defenders. We've worked with federal public defender. We've worked with law enforcement. So quite a variety of clientele.
Civil cases?
Yeah, civil and criminal. I would put it at about 60% criminals, 40% civil.
Okay. And on the criminal side, you've done both law enforcement and defense, correct?
Yeah, most of the law enforcement ones, though, have been more geared towards civil. It's when they had perhaps they were party to a suit, and it was just improper for them to use their own experts. So that's where we've provided assistance.
Now, how long have you been involved in the field of data forensics?
Sure. Well, my first case and testimony was 28 years ago. I'm not even sure we called it data forensics back then, but that was 28 years ago. And then about 16 years ago, started the company United States Forensics, and been full-time in the industry since that point.
All right. Now, you'd mentioned that you'd actually testified for the first time 28 years ago. That would have been 1996, if my math is correct?
That's correct.
You were qualified as an expert witness at that time?
Yes, sir.
In order to have been qualified as an expert witness, you must have had experience before that?
Yeah, it was specifically in computers. We didn't do much with cell phones back then. By about a decade or so in computer IT, networking. We actually built a line of computers, a lot of repairs. So I was pretty deep into the computer IT world at that point.
Okay. And you say you formed your company in 2006?
Correct.
And you work full-time, part-time? What's your schedule?
Oh, it's been full-time ever since.
Would you describe for the jury, please, your educational background, your training, certifications, etc.?
Why don't we break it down into smaller segments?
Sure.
Okay.
First, with regard to the training that you've received.
Sure. So the that would have to do with associates of digital forensics.
Well, that would more be your education, right? You received an associate's degree in digital forensics?
Correct.
Okay, so why don't we start with education, since you did?
Okay. Well, that was part of the work and more or less the formal training to get that degree. The certifications, which again, this all kind of goes hand in hand, but the certification training would be the CCE, which is certified computer examiner from the International Association of Criminal Investigation Specialists. I also have a certification as a computer crime related investigator, cybersecurity, as well as computer first responder. The training aspects over the last 18 years on really a daily basis, when I've worked, I've participated in listservs, done research into the newest developments in the computer forensics, and really on usually a weekly basis, we'll target some training seminar. I found in this business, even if you took like 6 months off, you would start to get behind in this business. It changes that rapidly, and you really need to do continual training.
Okay, and again, your voice trailed off a little bit at the end, so
I'm sorry.
I'm sorry to keep reminding you, but I just want to make sure everybody hears. With regard to the amount, your caseload at USA Forensics, can you give the jury some idea of how many cases you handle on a yearly basis or have handled historically?
Yeah, we average, I'd say between 100 and 120 cases a year. We probably get inquiries to about 3 times that amount.
Okay, and have you testified as an expert witness in the area of computer forensics since that 1996 first appearance?
Yeah, we testified about 2 dozen times in various state and federal courts.
2,000 times he's testified, and he's been qualified as an expert each of those times. He's been qualified as an expert over 2,000 times. That's huge.
Okay. And when you say various states and courts, is that state court, federal court, both?
Both.
Now, directing your attention to September of 2022, were you contacted by somebody to become involved in this matter?
Yes, sir.
Who that was?
I believe it was Miss Little.
What were you asked to do?
Well, there was 3 cell phones related to this case, and to provide relevance with the data on those phones as it related to the incident on January 29, 2022.
Okay, and were you aware of the owners of those 3 phones?
Certainly. It was Karen Reed, John O'Keefe, and Jennifer McCabe.
Now, I'd like to ask you first, if I can, about John O'Keefe's phone. How did you receive the data from that phone, if you remember?
Yeah, we received what's called.
Okay, everyone listen up. So this is interesting. So this is, now he's going to talk about John O'Keefe's phone for the first portion of his testimony. And just note that the Commonwealth is not asking to keep out any portion of this testimony. So Olivia, if you want to comment on any portion of this John O'Keefe testimony, just tell me to stop.
Okay.
Okay.
Called an image file, and that's a forensic term that we use. Essentially, it's a copy of the data that's encapsulated into a single file. In this case, it was a zip file.
Did you examine that data?
I did.
What were your goals during your examination of John O'Keefe's phone? What were you looking for?
Well, initially what was supported was the location data. We wanted to get an idea of when he had arrived and anything else that we could tell from that as far as location.
And when you say when he arrived, do you remember the location that you were asked to learn when he arrived?
34 Fairview.
In Canton?
Yes, sir.
All right. Were you able to determine, as a result of your examination, approximately when his phone arrived at 34 Fairview Road, according to the location data?
Yes, sir.
And how did you do it?
Sure. Well, I say we, so that's a proverbial we. I extracted the location cache data, which is stored in the on your phone, and it's in the certain location. We exported that out, and then we use a tool called CellHawk, and we import it in there, so it can take literally thousands of data points and automate that process to specific GPS locations, and just as importantly, the range of accuracy that that location is reporting.
Okay. So according to the process that you underwent, what time did the location data indicate that John O'Keefe's phone arrived at 34 Fairview on January 29th, 2022?
So the first one right to the driveway was at 12:24 and 28 seconds.
12:24 and 28.
Correct.
Now, if I asked you to filter John O'Keefe's location data within an accuracy of 3 feet using CellHawk, could you try to do that?
Yes, sir.
In fact, did you try to do it?
I did.
When?
Okay. So he can estimate his location within 3 feet with CellHawk.
Yeah, so it's funny because I've been obsessed with the digital GPS data, like since the beginning of this case, because it's the one thing the Commonwealth tries to claim is their definitive proof that John didn't go in the house, right?
Right.
But yet the Commonwealth, as we previously discussed on this show, they didn't even look at John's GPS data until 15 months after the fact, and only after the defense first looked at it. And of course, it was problematic for the Commonwealth's narrative. But CellHawk, the tool he just mentioned, that is a digital forensic tool software like Celebrite, but it's specifically tailored to digital GPS and location data forensics. And so with Cellhawk, you plug in not only the extraction data from the cell phone, but you also plug in the CDRs, the call detail records from Verizon or AT&T. So that's like the cell site locations, right?
Mm-hmm.
And so you have, for first and foremost, you have far more data that is going into the analysis with Cellhawk. It's not just looking at location data points from just the physical phone. And with Cellhawk, it not only maps with specificity because it doesn't introduce into the mix things like human error when you decide, instead of using the plug and push software, we're going to go to the scene of 34 Fairview with our yardsticks and measure out the data points, that only the data points from Waze,
Right. Which is what they did, right?
which is what they did, which, when you think about it, we know that Massachusetts State Police, they regularly use Cellhawk in their criminal investigations. In fact, there's an investigative journalist who he does these really in-depth investigative reporting on like how much public agencies spend on certain things, which it can be hard to find that information out from like police agencies. How much do you spend on your digital forensic tools, and how much do you spend on Cellhawk a year or on Celebrite a year, for instance? Um and he was looking into that information with MSP, uh and they refused to give him the exact numbers or information regarding the numbers. So he asked them for a public records request, looking for like all the emails or times, iteration, different times that it's mentioned amongst their investigators. Because of course, if you're not using Cellhawk, you would never be talking about it in your
Right.
emails. And
Right.
anyway, he found like significant evidence that Massachusetts State Police uses it, but we know that they use it because it's referenced in many of their other investigations. But even, beyond just Cellhawk, like there are tools within Celebrite that allow you to do a similar type of analysis, although it's not as in depth as what Richard Green did on Cellhawk, that creates a map. You can use the physical analyzer tool to carve location data. And what that means is basically it will find artifacts for location data that may have been deleted, that may have been you know altered or difficult to find evidence of in your forensic analysis. And Guarino didn't even do that. I mean, why didn't he even use the Celebrite physical analyzer tool to look at the location data on the
Mm-hmm.
phone? Why would you opt to, instead of staying at your desk in your office and pushing a few buttons, and using a software, why would you opt to drive all the way physically to the scene to measure with yardsticks, physically measure out and do this far more involved process that inherently introduces unreliability, introduces sources of error, um if not for, it allows you to make the data fit your narrative.
Right. When you're trying to reverse engineer a theory, that's what you do. Right.
I mean, I put it this way, I can't think um of any advantages or any reasons that would explain why that is the preferred option, right? There's no advantages to that
Mm-hmm.
method. If anything, it's not forensic, it's not scientific, it's not reproducible. And but also just think of human nature. I mean, human nature is usually to do the take the path of least resistance, right? Like
Mhm.
if you have a software tool that's on your computer that you know is going to give you the most solid, admissible, credible, reliable evidence, if you really have a strong case, right? Like, don't you want to use that tool to show just how guilty this person is, or
Mhm.
to just effectively prove your point? Why would you choose the path of more resistance, where you have to go drive to the scene, you have to physically measure out these uh with yardsticks
Mhm.
in an area that has really bad cell service?
Right.
It strains credulity, as you
It's
would say.
It's strange credulity is right. Right, let's see what else he's got to say about this. Sir, in fact, did you try to do it?
Last night.
Who asked you to do that?
You did, sir.
You did it last night
Let me approach you on it.
because this was the day after Garino testified.
Yeah, and guess what? Ian
Mhm.
Whiffen didn't use the correct iOS version.
Whiffen didn't?
Or sorry, yeah, Whiffen. Did I
Yeah.
say Richard? Whiffen didn't use the correct iOS version that was on Jen McCabe's phone. Richard Green did.
Yes, exactly.
So I placed that document before you. Could you familiarize yourself with that and look up at me when you're done?
All right.
Recognize that?
I do.
What is it?
So this is a screenshot from the CellHawk program. It has a kind of a central box here that says database settings, and this is where we apply a certain filter.
And what filter did you apply?
This was for the accuracy of less than or equal to 3 feet.
With regard to what?
John Oakey's location data.
Is that an exact? Is the data on that document exactly what you received when you used the CellHawk program to filter the data?
Yes, sir.
I would offer that, Your Honor.
No objection.
They didn't object to it, which is interesting because they just did it the day before. So okay, Lally let it in.
No objection.
Oh, I'm sorry. I thought you said
He
objection.
actually, Richard Green actually, he did his CellHawk analysis. Look at, that's the GPS location data analysis. He did that back in February, March of 2023 in his his initial affidavit that he filed for the defense with the Google search with all those bombshells. He had already done this analysis by that point. I think what he did last night was he went more, he further stratified the data from that analysis. So he filtered down, how we were talking about with GPS, there's
Mhm.
an accuracy value for every data point. So it's like you have your latitude,
Right.
your longitude, and then your accuracy, or your margin of error is another way of looking at it.
Yes.
He looked at in his, when he did an analysis the night before here, I think he was refining that data down to look at the data points with the accuracy of 3 feet, which is crazy that CellHawk can do that. I don't know how reliable, like I'm of the belief that GPS, well, I think the defense would benefit from bringing in addition to, a Richard Green, they would benefit from bringing in a GPS expert,
Mhm.
because it's very nuanced, and there were a lot of factors at play that night that would severely hinder the accuracy of GPS.
Right. The weather, the bad self-service, trees.
Hmm.
Okay, let's go on.
So you need to give it to Madam Court Reporter.
I'm all flustered. Sorry. With permission, I'd like to publish that one.
Okay.
So, Mr. Green, what are we looking at?
Okay, so that is the screenshot from the CellHawk.
And what can you tell us about what you learned from that exhibit?
Well, I'll just use the pointer here, might help. You can see up in this part here where this is where we apply the filter for 3 feet or less. That'd be the accuracy. And then it actually returns 0 results, meaning all of the data within there had a an accuracy rating higher than that 3 foot. It could be 5 meters or 10 meters, but none of it was granular enough at a 3 foot or less accuracy level.
Oh, and if you had inputted accuracy within, say, 500 feet, what would you find?
Yeah, you would see then a large number of circles, each circle representing the meters that the accuracy would be related to. What's really important to understand, though, is you don't want to look at just the middle of the circle. That accuracy indicates it could be anywhere in the circle. So if you saw one and it encompassed 2 or 3 houses, you could only draw that inference of somewhere in that circle. So it's kind of like how the hurricane, they say don't just look at the cone, right? Because it could be different than that. Also, the accuracy, this is Apple's best guess at what the accuracy is. So it could actually be different than that. It's Apple is using a number of services, and they're giving back the best estimation that they can for the accuracy.
Okay, so we've talked about the location cache data and where it put John O'Keefe's phone in terms of arriving at 34 Fairview, but was there also Apple Health data on John O'Keefe's phone during that time?
Certainly, yes.
Is Apple Health data generally accepted within the forensic science community as being reliable?
Well, the Apple Health data comes from something called HealthKit, but it's integral to the iOS system. So anyone that has an iPhone probably seen Apple Health data, and it's known to have extremely valuable data that the forensic tools work with and present to us. The degree of accuracy, it depends on the type of data that's being pulled out on the artifacts. For example, steps are known to have an accuracy of around 98% on the actual steps occurring.
So if the Apple Health data returns, for instance, steps of 20 steps within a certain time period, 98% of the time Apple's going to be right?
That's what studies have shown.
All right. May I?
Okay, Olivia, you agree with that? Apple Health data is 98% correct?
So I was
Correct.
actually just typing in the chat, but if anyone's interested in looking at it, there's a thorough scientific study that was conducted by the Hague, Netherlands, where they did an in-depth analysis of the reliability, the accuracy and reliability of Apple Health data.
Mhm.
And that's probably one of the top sources that I've heard digital forensic experts refer to when discussing Apple Health data. And, just, of course, it's, it has errors, it has its quirks and things like that. But the problem is when you're talking about the setting of a criminal proceeding, there's not evidence to suggest that the data are wrong, right? Like if you had some exceptional circumstance or something that occurred that could explain for why one's movement data may be fluky at this given minute because you have them on camera like doing crazy maneuver or jumping jacks or what flailing their arms around, okay, but they don't have anything like that in this case, and yet they offered that to try to explain why you can't rely on any of
Right.
the Apple Health data. However, with the exception being, we still want you to rely on the accuracy and credibility of the Apple Health data for when John's phone's last movements were
Right.
at 12:32 a.m.
Mhm.
To try and fit a timeline, although our timeline keeps changing because we said he was originally hit and killed at 12:45 a.m. So
Mhm.
we don't really know what happened. But yeah, I mean, can you say disingenuous?
Yeah, 14 times. All right, keep typing.
But
Keep
yes,
ty-
that's an accurate reference from Richard
Good.
Green regarding the Apple
Right.
Health data.
It's another example of shield and sword. Yeah, like you can't believe that he went up and down 3 flights of stairs because that's not accurate.
Oh,
He could have just been
Lindsay,
going over a hill or flailing his arms around, but you're supposed to believe that it never moved after 12:32, his phone.
well, amazingly, the same Massachusetts State Police, like the ones who investigated this case,
Mhm.
they actually find Apple Health movement data incredibly reliable because in the Lindsay Clancy case,
Mhm.
who the Massachusetts State Police investigated, in fact, if you go back to her, not arraignment, but it was her it was that first hearing where she was physically there in person, and the footage is a little blurry, kind of blurry, but the prosecution, they're reading through their evidence, and they specifically cite to when Lindsay Clancy climbed flights of stairs in her house to
Mhm.
show when she went from the basement where she committed the atrocious crimes and
Horrific.
climbed upstairs all the way up to her bedroom, to where they allege she started, you know, self-harming before going out the window.
Yep.
So it's amazing, it's gold standard, reliable, credible evidence. That's how the Massachusetts State Police apparently utilizes it, but
Not
I
in this
guess not
case.
here.
No, not in this case. Let's keep going.
I approach the witness, Your Honor.
Yes.
You want this back? Okay.
Mr. Green, I've placed another document before you. Do you recognize what that is?
Yes, I do. This is this lists out Apple Health data for that was from John O'Keefe's phone on January 29th, 2022.
That came from the data that you received, the image file of John O'Keefe's phone, correct?
That is correct.
I would offer that, Your Honor.
Mr. Lally?
No objection.
I'd like to start with page 2, record 2.
Yeah, I probably need bifocals here. I keep switching glasses.
Here you can look on your document in front of you. It's page 2, record 2.
Yeah, I think I'm going to have to.
Page
I'm just
2
going to fast forward this a
show
little
on
bit.
page 2 of John's Apple Health data.
Sure. So this is the number of meters. It's listed as 87.74, and the time is listed between 12:21 and 10 seconds. And there's a milliseconds after that, but I'll just round it off to the second if you don't mind. So 12:21 and 10 seconds to 12:24 and 22 seconds.
Okay. And you said that it showed 87 meters traveled during that time period?
Correct.
And with regard to that same time period, 12:21 and 10 seconds and 12:24 and 22 seconds, please turn to page 5. And Mr. Bates, if you would zoom in on record number 2.
I have that.
Mr.
Okay.
Bates.
What
Tiny
does
desk
record
man.
number 2 reflect?
Again, it's the same time period, and the steps taken is recorded as 80 steps.
Okay, and you said the same time period, so again, 12:21:10 to 12:24:22, correct?
Correct.
All right, now I'd like to direct your attention to page 4, record number 1.
And they're not opposing any of this stuff coming in. He walked 80 steps after 12:21, right?
When you're ready, Mr. Green, if you could tell the jury what that reflects.
Sure. So this indicates 3 sets of floors. That represents elevation change. So it doesn't indicate to us up or down, but 3 steps. And the time period for that is 12:22:14 to 12:24:37.
Okay, did you say 12:21:14 to 12:22, I'm sorry, 12:24:37?
Yeah. 12:22:14 to 12:47:37.
Oh.
I see.
This is
And
the stairs,
with
yeah.
regard to
My
all of
bad.
this data.
So first it was like
steps,
80 steps, right, at 12:21, and then starting at 12:22:14, 3 flights of stairs.
Mm-hmm.
and the 3 flights of stairs that you mentioned, is it possible to pinpoint where within the time frame that's given those steps or flights of stairs were ascended or descended?
No, the most granular we can get is the time period, and it doesn't signify as any more likely at the beginning of the time period than at the end of the time period than at some time in the middle. And if you think logically, like distance traveled, that doesn't happen at a split moment. It happens over a period of time. So it's time is a factor in that equation, and this is how the Apple records that data. You got to look at the time overall.
Okay, so you don't know if it's the steps are bunched up toward the beginning or toward the end or more evenly spread out.
No, I would not be able to tell you that.
Now we've discussed the Apple Health data. I want to go back for a second to talk about the location data on the iPhone. Does that data that you've already talked about in terms of the arrival time that it gave for John O'Keefe's phone at 34 Fairview, does that arrival time fall within or outside the range of 12:21 and 10 seconds, or 12:21 and 10 seconds and 12:24 and 37 seconds?
Well, that certainly indicates an overlap, but the health data is ending after the arrival. And
Now, I'd like to discuss with you the concept of clocks used by apps on an iPhone.
Sure,
Are you aware of the 3 different clocks that are used by iPhone apps?
I
Mhm.
am.
What are they?
You have you have 3 separate internal clocks. You have a monotonic clock, a baseband clock, and a wall clock.
Yep.
Okay, and is the wall clock also called a display clock?
Yeah, that would be also a common name for that.
And what is the significance of the existence of 3 clocks regarding different times that may show up within these records?
Sure. Well, app developers can access Apple program library, and they can call upon any of the clocks to use within their apps.
Okay. Now, in your investigation and examination of this case, did you find examples on this phone of different clocks being used?
So in this particular case, I had reprocessed the data with the newest version of the Axiom forensic program. It's similar to Cellbrite. There are competitors to Cellbrite, and we use both programs. And this newest version had a feature in there where you can filter for the Waze application. And again, just following up and seeing how this functioned, we filtered for the Waze application. And for the first time, we saw this monotonic timestamp being related to the Waze application.
Okay. I want to show you Exhibit 640, if I may approach, Your Honor. I've placed Exhibit 640 before you, sir. Do you recognize what that is?
Yes, sir.
What is it?
So this is a screenshot from the Magnet Axiom program I was referring to. It's the 8.1, actually it looks like 4287, but
Keep your voice up, sir.
I'm sorry. Yeah. So it's the newest version of the program, and we have it filtered for the Waze app, and it's giving us the timestamps associated with it.
With the court's permission, may I publish that?
There we go.
Yeah, it's like 12:22:30, I think, for the monotonic.
It's like the Waze is like 3 minutes off or something. Right?
Yeah, just shy of 3 minutes, I think. I
Okay,
believe.
thank you. I'll go off
You'll
this one.
see yeah, 12:22:30 for the monotonic.
With regard to what we are looking at there on that part of the
So-
screen, what are we
If you want to
looking at?
pause it for a sec,
Yeah.
this is a thing we talked about the other day with the GPS data.
Hmm.
Because Guarino was only looking at GPS data points that were sourced from the Waze app on John's phone. Waze is a third-party app on an iPhone, and it's also a navigation app. And most third-party navigation apps will use monotonic time. It's a time system that they use because for the difference with monotonic time is that it's more of a time measurement of duration, and that is far more important when you're using like a navigation app and you need to know what time you're supposed to arrive at your destination.
Right. Or the
Um,
fastest route or how long it's going to take to get there.
Right. So things like oh, I'm forgetting the example, but in other words, there can be discrepancies between monotonic time and baseband time. And baseband time is display time, which is the time that your phone shows, for instance.
Hmm.
And so, yeah, with the Waze data in this case specifically, because you can pull up when you're parsing location data, you can pull up the time programming information, which is obviously very, very relevant, particularly when you're sourcing your data uniquely from the Waze app,
Hmm.
because the Waze app is not a native Apple iOS app. It's a third-party app. And so that means that it can be using different systems than the iOS system, than the display time. And it's curious why Guarino didn't look at location data from any other sources on the phone but the Waze app. It seems to lend to the idea that he was aware of this fact, allegedly, and potentially exploiting it. I mean, that's just my opinion, but
Hmm.
it seems like it seems like it's quite a coincidence. And why would you use less data in your analysis if you can use all of the location data from all of these other places on the iPhone? Like the weather app, for example, is checking your location in the background frequently.
Right.
Why would you not use all these other data sources in your analysis? Well, because native data sources would have the correct time, which would mean John O'Keefe arrived at the time his Apple Health data, in line
12/21/10.
with the Apple Health data. Yeah.
Right.
And that puts him in the house, of course.
Right.
So
Right. Well,
it's a,
either Guarino's incompetent or he was intentionally hiding something.
well,
You can't have
that's
it
the
both ways.
thing.
He missed 32,000 text messages between Farwell and Sandra Birchmore. So there's that.
Yeah, it's the easy argument to make that he is incompetent because he missed all these things. Because of course, we're not responsible for proving if he's being nefarious or not.
Right.
The feds or whoever will take care of that. But all we know is that he missed an exceptional amount of evidence in that case. That is the difference between this poor young woman being framed for
Right.
her own murder
Mm-hmm.
versus a murderer who was a former police officer
Yep.
being rightfully charged.
Right. And so when there are law enforcement officers involved in the case, Guarino has a different set of tools that he uses, perhaps. Just saying my opinion, because
It would
I'm sure
appear.
in other investigations, Guarino is spot on. And maybe and I would love to see other investigations that he's done that do not involve any law enforcement officers to see if he's been able to use other things like Cellhawk and if he knows the difference between the Waze monotonic clock and the display clock on the iPhone. And if he's accounted for that in any other cases that he's testified in, because I don't think this is the first time he's ever testified, right?
Right.
There's
Well,
another
you wanna-
rabbit hole to go down.
Yeah, you want to talk about misinterpreting digital evidence.
Hmm.
This would be a prime example of it, which is precisely why I say put the Commonwealth on notice. Have Jessica Hyde and Ian Whiffen look at the entirety of the phone evidence, at
Right.
the GPS location data, because they will very quickly come to the determination that the timing that Guarino's trying to put forth is a misinterpretation. It's incorrect. But beyond that, you want to know what's interesting? In
Hmm.
another case that the same DA's office is responsible for, the Brian Walsh case,
Hmm.
um, Guarino he's not the go-to digital guy. He's not the go-to specifically GPS location forensics guy. In fact, they have another officer who is in the Norfolk County DA's office's special state police detective unit,
Hmm.
whose last name is Keefe. I'm forgetting his first name because they actually have, believe it or not, 3 officers in that unit that have the same last name, Keefe. It's not Connor Keefe, who's already mentioned in this case. It's a different
Right.
Keefe who is the go-to digital forensic expert and digital GPS location digital data expert for the DA's office in their investigations. He's who does that analysis and that investigation in the Brian Walsh case.
Hmm.
Guarino went to him for that.
I remember. And I remember because I went over this when I did a stream on Walsh, that one of the reasons that they're trying to pinpoint the certain dumpsters that he unfortunately threw the trash bags of his wife's body parts in around town. One of those dumpsters was at his mother's apartment
Mhm.
building. And they say in part, I think it's a probable cause affidavit of some sort, that they could tell the difference because on one of the days his phone was found in the location of where the dumpster of that apartment building was. And on the other day, he was inside that apartment building. And so they're able to pinpoint with pretty good accuracy in Brian Walsh where his phone was, which I submit to you
Oh,
in this
yeah.
case would be perhaps the
Well,
same distance from the street into the house.
so I think so that case is interesting because he did a lot of things across a period of days, right? Like going to the Home Depot
Hmm.
and being caught on camera buying all the supplies and I mean, it would make sense that there would probably be a number of dumpster visits. I think that on the first day, he left his cell phone at home actually,
Mm-hmm.
which is interesting. Um, but they still pulled the GPS data from his vehicle. And but the other thing that's important that they did in that case is even when they had GPS location data, whether it be, from the vehicle he's using or the cell phone or what have you, they also, crazy thought, pulled surveillance footage from the same areas. So it's like that's how you corroborate evidence, because if you have the GPS location data, it's kind of hard to dispute its accuracy when you also have camera footage putting that person in that location at that time.
Right. Wouldn't you want the most evidence that you could get? The
Yeah,
most
and
evidence to prove that this was really a car accident?
well, that's the first thing you look for. I mean, the first thing cops look for in any investigation I've ever looked at, you hear about, I mean, with the Luigi Mangione, with the thing in New Orleans, you always go and pull surveillance footage.
Mm-hmm.
And why wouldn't you? I mean, it's like
Of
the
course.
best direct evidence. You don't have to persuade or convince a jury of anything. If they can see the person committing the crime with their own eyeballs, like
Mm-hmm.
that's the most compelling evidence you can get. And yet, in this case, they didn't even bother. Well, I mean, who knows, like they didn't even bother asking anybody in the neighborhood, let alone the house across the street that has cameras on its house pointing directly at their crime scene. I mean, what a like a blessing for investigators. Can you imagine how many murders these
Mm-hmm.
investigators respond to where they would do anything to have surveillance cameras in the vicinity?
Yep.
And Kelleher's house, I was just looking back again the other night at the photos of his house outside. I believe I counted 3 cameras in total on the outside of that guy's house. There's one
Mm-hmm.
on the front door, there's one on the far left side that is the closest front corner of his house to 34 Fairview.
Mm-hmm.
I mean,
Well,
pointing at the scene.
apparently, Tom Kelleher, for those of you who don't know, was the deputy chief of the Canton PD on the day of the incident, January 29th, 2022. He lived a little bit, like almost directly across the street from 34 Fairview, and he's the guy they got the solo cups from. Apparently, he never came out of his house either, because that's what all these witnesses are saying. Well, nobody else came out of their house. Why does it matter whether Brian and Nicole came out of their house? Nobody else came out. Tom Kelleher, who was the deputy chief of Canton PD, whose guys were the first on the scene, never comes out. Somehow he gives them solo cups, and it's his cameras that are pointing in that direction. But apparently they asked him if there was anything on his cameras, and he just said, "Oh, nothing interesting." And they didn't like look at it or seize it or subpoena it
Yeah,
or
you're telling me that cops see 3 cameras on the outside of a house that is across the street from their murder crime scene,
Mhm.
and they're just taking the guy's word for it. The
Yep.
guy who happens to be colleagues with the brother of the homeowner that
Mhm.
the murder crime scene is located at. Yeah, that
Right.
makes a lot of sense. There's a reason why the cops, they don't usually take people's word for it, because guess what? People can lie. People
Right.
can be evasive.
Right. What about all the cameras from her leaving the neighborhood after she allegedly hit him? That may show her taillight. Wouldn't they want
Right.
those cameras? What about all of the cameras from Meadows, from when they went to Meadows to Dighton? What about all those cameras? Because all of those cameras might have shown the taillight too, including, red light cameras, the flock cameras that they seem to have at traffic lights
Oh
around the
yeah.
area. They never
They've
looked for
got a
any of
lot of
that
flock
stuff.
cameras in Canton.
Yeah.
And you know what else? You know what I was thinking the defense should do at the next trial? They should, it may be like a little exhaustive or a little drawn out, but I think it could have a powerful effect. And that would be to call, because I'm assuming, I mean, their private investigator seems like he's been on it from the jump, right? I mean, he interviewed Lucky Lofgren
Right.
like in February,
Mm-hmm.
almost immediately. So I imagine he spoke with neighbors along Fairview Road. what they should do at the next trial is the defense should just call a series of neighbors, people who lived along Fairview Road at the time,
Mm-hmm.
and one by one, call them up. Hi, can you please introduce yourself? Did you live at 36 Fairview Road on this date at this time? Yes. And then ask the witness, okay, and did the state police, the Canton police, or anybody for that matter ever come to your house and ask you if you have any cameras or
Right.
ask you if you heard anything? And
Yep.
I mean, my assumption is that all of these witnesses will say no. And so you call one after the other, after the other, after the other. You don't have to call 30 or 100, but if you call like
Mm-hmm.
5, I
Yep.
mean, that's pretty damning. Why didn't they go to ask these people if they had cameras on their houses, or even the people who did have cameras, call all those people? Why didn't they come in and ask you for your footage?
A lot of people are saying that Turtle Boy did ask, and some neighbors, and they said no. So I don't know. I'll trust you guys in the chat that have watched all the Turtle Boy shows,
he
but
did do that. He went to a handful of locations along the route
Mhm.
and asked, and I don't think he found one person who said yes that they did. So, but I imagine I imagine the defense investigator did that too, because he seems to have a lot of information from neighbors in the neighborhood.
maybe some people will come forward. Maybe some people will come forward in the interest of justice and say, you know what? I did come out of my house that night. In fact, I took pictures of the crazy scene that was going on there because somebody did. One of the neighbors did. Maybe there's some people who live in the neighborhood who are not afraid anymore because they're so outraged by what's going on here and this railroading that is going on. And they're so sick and tired of the decades of police corruption that may or may not have been going on. Who knows?
Mhm.
All right, let's keep going here because getting close on time.
Okay, so this is listing details of this particular artifact, and you can see that it's just bundled. The com.ways.iphone.
So basically, this testimony pretty much shows that this Waze clock is 3 minutes ahead, right, of the clock on the phone.
Correct. Yep.
And so that's why those
So
that
in other
data is
words,
skewed.
yeah, in other words, the timestamps, all of the timestamps associated with the location data in the Commonwealth's GPS location report for John's phone are off by whatever that difference
It was almost
was,
like,
that
I think it was almost
offset.
like 3 minutes fast, I think.
Yeah. And this is why you use forensic tools to analyze data, because when you have all these different competing data sources, some of them, it just so happens, operate on a different time programming system. And, Guarino might not be aware of that, or whether or not he's aware of it, a forensic software tool
Right.
protects from introducing that source of error, corrects, it standardizes all the data.
Mm-hmm. Yep. I'm sorry, Moon Goddess, they don't show us the anonymous letter. It's not attached as an exhibit. None of the exhibits were attached. They're not in the public file, so we cannot look at that. Yeah, there's an anonymous letter that they exchanged with the defense that's like 6 pages long or something to ADA McLaughlin. I have no idea what that is.
Do you think it's I was thinking maybe two things, like it could be maybe from a juror,
That's
or
what I thought too. That was my
I
initial
was
thought. Or
the
what?
other thought I had is, like, is this a letter that she received where it's supposed harassment or something?
Oh, I
I
don't
mean,
know.
because they seem eager to try and convict Karen Reed off of unsubstantiated claims of harassment from
Yeah, witness
unknown
intimidation.
sources.
Right. Well, it doesn't mean it's admissible. It just means they're exchanging it. So
True. It's important to remember.
Objection. Move to strike.
Sustained. I'm willing to strike that. Next
Okay.
question.
Wait, what did
That's
we strike? Hold
important.
on.
3 minutes may not seem like much.
3
Take a
minutes.
little.
Okay.
Of the well, there's the monotonic is running a little over 3 minutes ahead of the display. So I think it's 3 minutes and 1 second, give or take a little. So in a lot of cases, 3 minutes may not seem like much, but in this case, this struck me as important to
Right.
Objection. Move to strike.
Mhm.
Sustained. I'm willing to strike that. Next
Okay.
question.
And she's
I apologize.
striking it. Why is she, why? Why is she striking that, right? Anything that's unfavorable to Lally gets stricken.
I
And
will
also,
hand that back to you.
Hmm.
why is she striking that? Because he's not, the reason he's offering that is to explain why he did a deeper analysis into the data
Hmm.
and provide, I think, did that supplemental analysis, where he filtered down the data, not just looking at a more refined accuracy of the location data, but also looking at the time programming.
Right. And Guarino did not do that.
Correct.
Madam Court Reporter.
Certainly. Thank
And
you.
I'd like to go back to the Apple Health data, Mr. Baines, if you can put that back up. And this was to be page 2, record number 3. You do.
I do.
Page 2, record.
Okay, so this is another entry from John O'Keefe's data, cell phone data, and this records 25.46 meters occurring between 12:31:56 and 12:32:16.
Okay. And directing your attention to page 5, record number 3, if you could tell the jury what that shows, and if we can have that displayed as well, Mr. Baines.
Certainly. So this is directly related to the distance, and this is recording 36 steps, and it's the same time period, 12:31:56 to 12:32:16.
Okay. So we have 36 steps being taken according to Apple Health data on John O'Keefe's phone for a time period that ends at 12:32:16.
Objection.
Sustained. Ask it differently, Mr. Kennedy.
With regard to those 36 steps, do we know where within that time frame they were taken?
Sure. Let me reread that here. We January 29th, 2022, 12:31:56 a.m. It's actually 12:31:56.109 a.m. and 12:32:16.507 a.m.
Okay. All right. So now I'd like to switch, if we can, to Jennifer McCabe's phone and your analysis of that.
Okay. So
During
this
the
is what they're
course of
trying to
your
keep out. So he's saying, so are you disputing, Olivia, that his phone stopped moving at 12:32, or are you are you disputing that where he was when it stopped moving at 12:32?
So there's two different data sources when you think about where what John's phone was doing at a given point in time. Apple
Mhm.
Health data shows you movement, but it's not showing you location. But movement is still very important, especially. So here's the thing that's really, I think, overlooked with the whole defense's when they got all this data, right? And why they really highlighted the flights of stairs climbed at that time, because GPS data, and if you get any GPS location expert to testify, they will confirm this. They will tell you that GPS and location data from cell phones, from any digital device, are an estimate. Okay, so they're not meant to be exact. They're an estimate. And so the defense was well aware of this fact. I mean, you look at any other trials and you look at GPS location data, it's used to put somebody in an area being the key word,
Right.
at a time, but it's not to say, oh, this person was in the bathroom in the basement versus in the workout room or whatever, because it's not that exact. But a definitive binary way for the defense, because they're probably thinking, when they see the GPS location data for John shows when they arrive at 34 Fairview, his phone moves and is now overlapping with the house. But of course, GPS data is broad enough that they are not going to levy such a bold claim without finding other corroborating evidence. It seems like a pretty good and good faith way to show whether someone entered the house or remained out on the street or in a car is, if you have someone climbing flights of stairs, there aren't staircases on Fairview Road. There aren't staircases in a Lexus. And it's kind of like one of those binary things that occurred. And so the occurrence of the flights of stairs being climbed coincidentally right after John O'Keefe's location data shows him arriving at the house
Yep.
is compelling proof to show he went inside the house, because you're just not, you usually don't have GPS location data that you can reliably narrow down to such a precise you know, field of area to say this person absolutely went inside the house.
Right.
Because, well, also the other thing is like, you also have to prove that that person had their cell phone on them. You know,
Hmm.
this is all proving where the cell phone was. It's not
Right.
proving where John O'Keefe was.
Right. Right.
So, you
Right.
know, it's like the defense, the point of the flights of stairs thing is it's showing not only was he with the GPS data locationally inside the house. I mean, it makes sense that he would go inside the house that he was invited to and that he was driving over to go to an after
Hmm.
party at. Um, but beyond that, oh, we now have this next step, this next level of information that all all factors point to the fact that he went inside the house, and that's precisely why you investigate inside the house.
Well, yeah, you'd think. Not here, they didn't. So essentially, what we've just heard him say, expert Richard Green, and the Commonwealth is not trying to keep this part out, that John's location data shows that he arrived at 34 Fairview at 12:21 and 10 seconds, that after that, he walked 80 steps, after that, 3 flights of stairs, after that, 36 steps, and then 12:32. And they're
Yeah,
not contesting that.
and you know what else is quite troubling when you look at the Apple Health data. I did a post back on this in, I want like last, oh, not last year, geez, we're in 2025, 2023. I did a post on
I
this in like
know.
the fall of 2023. Um, because the location, sorry, the Apple Health data shows steps, flights of stairs climbed,
Hmm.
and it also shows distance, um, distance traveled, right?
Right.
And I found it very damning that at 12:32, you know, that last grouping of steps that were taken on John O'Keefe's phone,
Hmm.
um, I measured out the, because on Google Maps you can use a measuring tool that will tell you like down to the feet, you know,
Yeah,
how much
12:32 and
distance.
16 seconds right here. Okay.
Yeah, exactly. So at 12:31:56 to 12:32 and 16 seconds, it shows 36 steps were taken or 25.46 meters were traversed. And so I pulled up Google Maps at the time and I was just curious. I was like, let's see what the distance from, you know, the front door of the house at 34 Fairview is to the approximate location where John O'Keefe's cell phone, or not John O'Keefe's cell phone, where his body is found later, you know, or the next morning, right?
Hmm.
And it's it's exactly that amount of a distance from the front doors, 34 Fairview, or maybe it's the side door, one of the front doors from 34 Fairview to where his body is later found. And when you think about it, we had a lot of witnesses say how they were like window watching at this
Uh-huh.
after party, you know, watching Karen's every movement. Well, if something went down inside the house, that would make sense. You'd have people, you know, window watching because they're like, "Where's Karen? Did she leave? Is she still like? Make sure you know, make sure she doesn't come inside.
Hmm.
Uh, we got to figure this out. Like, did she leave yet? Is she still there?" So you probably have someone on watch. This is, you know, my opinion, but you probably have someone watching at the front door, and if you look at the data showing when Karen Reed connected back to the Wi-Fi at John's house,
Hmm.
it would make sense that she leaves sometime around 12:30. Um, and when you look at these data, the activity data from John's Apple Health showing the steps taken around 12:32 a.m., if John didn't go inside the house, then why does he have any set of steps taken that are the exact distance from the front door of 34 Fairview to where his body would be found, or or even to, because that's where they say her car last was, right?
Right, right.
If he didn't go inside the house, then why would he have that exact, right? Because
Yep,
in order to either go inside the house or come out of it, you
right.
have to cover that distance. So, but of course, I think the phone, of course, was already inside the house by 12:32.
Mm-hmm.
Someone's watching out the window for the exact second Karen leaves, and presumably runs that phone out from the front door, or the, the side front door, whatever you want to call it, uh, to where her car last was, to the place where John's body would later be placed atop of it.
Yeah, could be. Also, why is she texting John at 12:40?
Oh, and while we're at it, if you want to talk about troubling digital data, if you look in Guarino's GPS report,
Mm-hmm.
at the end of his GPS report, he states that the phone stopped showing any GPS data from 12:25 something, I forget the exact timestamp, but 12:25 something a.m. until 6:15 something a.m. And that, but they also state in their report, it's in the Commonwealth's opposition to the Supreme Judicial Court, that at 12:59 a.m. John O'Keefe's phone showed some sort of activity or movement. Now, my problem with this data point is that your phone doesn't stop logging GPS location data. It logs it while you're asleep. It logs it so long as your phone is on and has any sort of connection, whether it's to a cell tower, Wi-Fi. It is in the background logging GPS location data. Ian Whiffen has done studies
Mm-hmm.
on testing on this,
Oh,
and the fact that there's a hard cutoff, 12:25 a.m. all the way to 6:15 in the morning, that tells me that John O'Keefe's phone lost connection. And well, if that's the case, then that means there were human hands on that phone that were manipulating it, putting it into airplane mode, or
mm-hmm.
doing something to the effect that would cause it to lose connection, because it is there's no explanation for why there would be no GPS data points throughout the entirety of that night. And when you
Mm-hmm.
think about it, if his phone was put into airplane mode by somebody, that would explain, conceivably why Karen Reed kept calling so much, because the phone would go right to voicemail.
Right. It's too bad you can't testify at trial because you have a great way of explaining things. Thanks, Mick, for gifting 10 memberships, and then another 10 memberships because of Mick. 20 new people are members. Thank you, Mick, so very much. Joseph Kane came in and gifted another 2. Thank you, Joseph, so very much. We'll cover some of these at the end because I got to run soon. But let's get into the Jen McCabe stuff. We're going to let this. I'm going to I can't really speed it up too much. If it's too fast, let me know. But let's let him get through what he's got to say about her, and then we'll discuss it.
When you reviewed data from her phone, McCabe's phone, and you're now
18.507 a.m.
Okay. All right. So now I'd like to switch, if we can, to Jennifer McCabe's phone and your analysis of that. During the course of your examination, when you reviewed data from her phone, did you find a particular artifact of interest?
Yes, I did.
What did you find?
We found a Google search that happened. First of all, the search was how long to die in cold, and it happened at or before 2:27 a.m.
All right. Where was that search found?
Sure. So that the artifact on that was called a Safari Suspended Tabs artifact, and there's a database associated with that called the Browser DB database, and in a company file, which is by the same name but ends in WAL, which stands for Write Ahead Log. And the Write Ahead Log is where the data first gets written to, and then at certain points, that data then gets committed and written to the main database.
All right. So that, if I'm correct, that browserstate.db/wall file, that's a temporary file, right?
It's temporary by nature, but it's not. It's integral. It's part of the way the SQLite functions. So it's not like a throwaway file. It's part of the way the whole system works.
And is it helpful to you when evaluating artifacts?
Certainly, yeah. Just by nature of it, we'll find a lot of the newest artifacts in that wall file.
Now, how do you determine the timing in terms of the timestamp on the browserstate.db wall file?
Sure. So the wall file has different rows and columns. You can kind of think of it as an Excel spreadsheet. And in this one particular column had it was a time column. That'd be the nature of the data going into it. And this the heading on this particular one was last viewed time.
Okay. Regarding that Google search for HOS long, and I say HOS, HOS long, to
Correct.
and cold, found in the browser state DB wall file, what was the date and time for that artifact?
Sure. So that's recorded in what's called Apicola time, and it's actually the number of seconds since January 1st, 2001. So you end up with this large number, and that gets converted to present to us something that's human readable, and then you have to apply the offset for the local. So once you do all those calculations, that's where we get the January 29th, 2022 at 2:27
Okay.
in the morning.
The specific, do you remember the number of seconds after?
I believe it's 40 seconds.
27, 40 seconds.
Yeah.
Okay. And in what state did you find that artifact?
Yeah. So the specific artifact, or it comes from a record, and the record number on this is 4028, I believe, and it was in a deleted state.
Okay. Now, what would you normally expect to find along with the artifact search?
So you'd have the date and time, the URL, which the way the URL presents itself, we know that it's a Google search, but you also see a history of other places that tab has been.
And with this particular artifact, did you learn the full internet history of websites related to that record?
No, that wasn't possible. We were only able to get the one website. I would say, I'm sorry, go ahead.
Interrupted you.
Well, no, so we definitely got the one artifact, the Google search, and we have the time related to it, but we do not know everywhere else that tab had been.
What significance was there to you about the fact that the full internet history related to that record could not be recovered?
Well, I wanted to do a little deeper dive into that, and so I used some various other database specific tools. One was called Belkasoft X, which has an excellent database viewer in it. Sanderson Forensics, which is known to specialize in this type of work, and
ArtX?
I'm sorry,
ArtX?
you saved me. Yes, ArtX, which is a program known in the community for research.
And how did you sort of cross-reference
And
the three of those
Axiom.
together? How'd you use them?
And
So
Axiom,
all three
right?
of those tools,
That's four.
along with Axiom and Cellbrite, which I did, they do have a
That's
low-level
five.
SQL viewer as well. So I looked at the data
And
with all
Sequelite.
5 of those tools, and I found it to be consistent amongst all the tools.
And in addition to using those tools, what else did you do?
So I wanted to get a little more.
So he used 6 different programs, and it was consistent among all 6 programs.
So is the Commonwealth going to call, are they going to call people from each one of those different companies? From Belkasoft, from Sanderson, from Axiom, from Cellhawk, from Celebrate. Well, I guess they have. But the other thing is, I think the defense needs to clarify, Ian Whiffen, because Ian Whiffen's not here on behalf of Celebrite. He's here
I
on behalf
know.
of Ian Whiffen.
And that's why that motion that I read earlier, I flipped out. I'm like, okay, they're saying all this stuff, and Celebrite says this, and Celebrite says that. Well, where's your affidavit from Celebrite? Because what Ian Whiffen,
Right, yeah,
what they attached to that motion
exactly.
is a report. It's not an affidavit. It's not sworn to. It's a report. Ian Whiffen is not here on behalf of Celebrite, and if he is, you better clarify that.
Right. I
There's no
mean,
affidavit from Celebrite attached to that motion when they're
That's a
asserting
great
all of these
point.
things that Celebrite did. So,
mhm.
okay, go on. Sorry to interrupt, but I lose
No,
my
no,
train of
I
thought so
agree.
frequently that I just bust in and say what I gotta say.
I'm right there with you. No, I think that the defense, like, they need to put them on notice, make the demand these things, because it's just the whole filing today was full of misrepresentations.
Let's move on, because he did more work than Ian Whiffen did, because the only thing that Ian Whiffen did Ian Whiffen use Celebrite and his own personal program that he
Yeah. Yeah.
Okay.
So Ian
or
Whiffen
did he even use
used,
Celebrite, or only his what was the name of his app again?
I
for-
believe it was ArtX, which if you listen, Richard Green, he actually took the time to use Ian Whiffen's own program in his analysis. He's like, you know what? I'm going to go out of my way now that you're going to bring Ian Whiffen in here. Why don't we just use his program too?
Right. All right, let's go.
Context. One thing with this artifact, it is deleted. And one thing about deleted data, sometimes you get it all back, sometimes you don't, sometimes you get a fragment. Deleted data makes it very difficult to give you the whole picture of what's happening. So in this particular case, I want to see what other artifacts were around this time as it related to web history, and particularly this browser database file.
And so what do you compare the 227 AM search to in order to gain more information?
Exactly.
I'm sorry.
What the information was. So what we found is that when we looked at a particular URL, a particular website that was visited, and then searched using that URL, the browser state database entry is the last entry in all of that. So we could see searches, videos playing. There's an artifact called knowledge C that records the user's activity, but the browser state is the very last entry on the items that we observed.
And did you find other examples of that that you can speak to before this jury?
Yes, I believe we have one printed out there.
Okay. May I, Coach Lerner?
Yes.
Okay.
I place the document before you, sir. If you could familiarize yourself with that and let me know when you're done.
I have it.
What is it?
Okay, so this is another screenshot from the Axiom program, and it is showing a search that we conducted for raining men, and then it takes that search, and we have a couple different items on there. We set the date to begin in 1970 and ending in 2100. In other words, we only want to see artifacts that had dates associated with them, and then we listed them from the newest date to the oldest date. And this particular one, again, it ends up with the Safari suspended tabs artifact being the very last in the series of dates and times.
All right, I'd like to go through that, but first I'd offer it into evidence, Your Honor.
Okay. Any objection?
No, there you go.
No, but you can find Olivia on Twitter, Charlotte. I'll put it up. I'll put her Twitter handle up.
And with the court's permission, may it be published, Your
You
Honor?
want this?
Yes.
Okay.
Okay.
So we have a number of columns here. Could you explain to the jury what's going on with that exhibit?
Certainly. So I'm gonna switch glasses back here. Forgive me.
Do you need the light on, sir? Or are you okay?
No, I'm fine, Your Honor.
Okay.
Thank you much. I can certainly do this. So we're looking at here web-related history, and also I have the filter turned on for application usage because there's some log files, sort files that the iPhone keeps track of to record user interactions, and that can give us an idea of the history as well. And then, as I mentioned, we have it filtered so that's only showing dates that dates existed, and we took the earliest possible date to a date way in the future, and then it's listed and next to the date and time, you'll see a little arrow, and it's skinny at the top and big at the bottom. That tells you it's going from smallest, earliest time to latest time. And this particular view is showing us the last of that series, because what's relevant and really important here is that the Safari suspended state tabs ends up being the last of the entries related to that, not one of the beginning of the entries related to that.
And what is the significance of the Safari state tab being the last entry? What does that tell you?
Yeah, well, so it tells us that internet history happened before that, and the purpose of this tab on at least this particular iPhone with this very specific iOS version is to record the state of that tab when the user left that. And the whole purpose of that is if you're on Safari, you're on a website and say you have to take a phone call or answer a text message and you navigate away from the Safari app, when you come back, it remembers where you were and allows you to pick off from there. It also allows you to hit the tab button and see what other tabs you might have open and navigate to one of those tabs.
All right, so as I see the last tab, am I correct that the time is 1:29:22, same day, like 2:27 and 38 seconds? Is that what it says on your?
I'm sorry. I'm definitely getting a pair of bifocals. I apologize here. I feel a little silly.
Bifocal.
The
Okay, so
Google
this has
search
to do with the It's Raining Men.
Correct.
Yeah,
With regard to
okay,
what that tells
so-
you about
So
ahead.
really quickly, that brings me to another thing. The Commonwealth, they want to get in. Do you want to get into the facts here? You want to get into the weeds? Well, maybe we should talk about the fact that Jen McCabe's search history also shows that she's lying about the whole It's Raining Men story, how she looked it up that night because what was her whole reason? Like
Because her sister was kind of drunk and she did like
likes
a
it. Yeah.
and it was a
so-
funny video, a family joke.
Exactly. But the problem is actually when you look at Ian Whiffin's own exhibit, it's exhibit 6. Where is it? Oh my gosh, 617. It shows that search was actually made in Jen McCabe's phone on the 27th. The 27th at 5:49 and 30 seconds.
Right.
PM. And the reason why this is important also to highlight is because they're trying to I guess muddy the waters about the how long to die in cold Google search at or before 2:27:40 a.m. by saying, oh, she couldn't possibly have been making this Google search at that time because she was actually Googling ozone basketball or Googling Hakamam sports or whatever the explanation is. But the when you look at the tabs Jen had open, so a lot of people, myself included, just have a ridiculous amount of tabs open
Yeah,
in
me
your
too.
Safari app. And but you know, if you go through, like I have tabs in there from things that I was looking at yesterday and like a week and a half ago. If I were to go and make an incriminating hostile to dying cold Google search on my phone right now, and then close out all of the tabs that I had open behind it, or not even all of them, but some of them, um, it would it would basically show a timestamp for that moment right now when I'm deleting those tabs. But it
Hmm.
would but also you can see the timestamp data from when those searches were originally accessed for It's Raining Men. It wasn't
Right.
accessed on the 28th or the 29th. It was accessed on the 27th. Um, and so it's like, why would you make up a whole story around that? It lends to the fact that Jen McCabe wasn't searching those other things at that time. She was just accessing tabs she already had open with those searches in the background and closing, you know, subsequently closing them out.
Hmm. Exactly.
I think the defense should highlight that. I mean, it's in Ian Whiffin's own exhibits.
I think a lot of this
But
is confusing to lay people, you know? I mean, you understand this very,
yeah.
very well, and you explain it very, very well. The problem with some experts is that they explain it in a way that another expert might understand it, but not necessarily a layperson with no technology type background. You know, my eyes even glaze over when I'm watching this stuff and listening. And that's why thank
Oh,
God I have
it's
you, you know, and I think the
it's
average person does. And that's why it
mm-hmm.
needs to be. And we've watched a trial recently where they use PowerPoints in closing, and I can't remember exactly what trial it was right now, but I found it to be so helpful.
I was gonna say, I think, yeah, the
So
defense should
helpful.
do that at the, yep, because there's just way too much
Too much.
information in this case,
And one
and
hour was not enough to close.
oh no, not at all. And the Commonwealth is their strategy is to exploit exploit that fact that there's so much information and try to muddy the waters, try to draw and drag it out, try to overwhelm the jury with frivolous, irrelevant information.
Hmm.
Um, and yeah, I agree I think, you know, they definitely need, like, at minimum 2 hours.
Yes.
I mean, why are you putting a limit on like, especially after we've been here for like 10 weeks, you know?
Right.
But you know, when you look at these issues surrounding the Google search, there's a lot of other damning facts that don't that they just don't bode well for the Commonwealth. For instance, a great way to settle this whole dispute, this factual dispute, would have been for the Commonwealth to have gotten Google geofence.
Right.
Interestingly enough, not only is that something the Commonwealth avoided getting, but it's actually something the defense requested.
Hmm.
And it was court ordered for preservation back in like the summer of 2022. The
Yeah.
Commonwealth had to send, you know, notice of preservation to Google geofence to preserve that data so that their systems, their databases wouldn't purge it after whatever their 6 months or however long it is. And when you look at the insidiousness of what went on with that whole matter, it is very troubling.
Hmm.
You know, Michael Proctor, he deliberately messed up the messed up no, he deliberately asked for the wrong things from Google geofence repeatedly, but he also misrepresented to the defense what he'd done.
Hmm.
He sent them, you know, old emails that he had sent, basically purporting as though he had just recently reached out to Google geofence to correct the issue. Anyway, long story short, for people who are unfamiliar with the whole Google geofence saga, when the Commonwealth was court ordered to preserve that data, they basically sabotaged the process because they knew that Google geofence, their 6-month window before their servers automatically purge old data that's stored in them,
Mhm.
they knew that that was fast approaching. That's why the defense filed an emergency motion to preserve it. And so they exploited that fact by uh asking for the incorrect things, asking for things that would, asking for Android phones, asking for the wrong time windows. uh you know y- you can't tell me that that was just another innocent mistake.
No,
And
because everyone had an iPhone in the house,
right,
right?
and wouldn't they themselves be eager to get that data? Because, if in fact Colin Albert wasn't there at the time in question, if John O'Keefe didn't go inside the house, if Jen McCabe didn't make this Google search at 2:27 a.m. and she actually did it at 6:23 and 6:24 a.m., Google Geofence would answer all those questions. It would
Yep.
show exactly where everybody is at any given point in time. You know what it would also show? It would also show if there were other people in the area of the crime scene that the Commonwealth never even learned about.
Right. Could be a whole different third-party culprit that has no connection to that house whatsoever, right?
Yeah,
Who knows?
exactly.
And then
Who
then
knows?
Higgins testified he saw some man walk in the house that he didn't recognize, that was tall and had dark hair. Like, what was that about? Let's go
The
back to this
fact of
for
the
a sec.
matter is they didn't know. I mean, they weren't there,
Mhm.
investigators, they don't know.
They don't know. They don't care. 16 hours they classified this as a hit and run.
What I
Mhm.
want, what I want is the timing of the interaction with training and by the actual iPhone user. When did that happen?
Certainly, all the activity that we have is all prior to the recording of that timestamp in the browser state.
All right, now, with regard to this particular example where the browser state DB is the last entry, so the activity happened before, was that unique on this phone, or were there many examples of this?
No, I found many examples of this exact behavior.
All right. Now, given your findings in researching these issues and how this user used this iPhone with this iOS, do you have an opinion to a reasonable degree of scientific certainty as to the timing of that search for Haslam to Diane Cole?
Objection.
Sustained.
See,
Do you have
sustained. Do you have an opinion? I mean, that's exactly what he's there for.
Wow.
To give his opinion with a reasonable degree of scientific certainty. That is exactly the reason for his testimony. And she sustains this. So just I want to play that again. I'll put it back
Amazing.
to regular speed for a second.
It's almost like they don't want to know the truth.
Nope. They want a conviction. They don't want the truth.
User used this iPhone with this iOS. Do you have an opinion to a reasonable degree of scientific certainty as to the timing of that search for Haslam to Diane Cole?
Objection.
Sustained.
Do you have an opinion to a reasonable degree of scientific certainty as to when Haslam to Diane Cole was searched?
Objection.
Sustained. I can see you at sidebar.
Thank you.
Again, here's the
Unbelievable.
sidebar. That's the exact opinion. And he's kind of smirking, Richard Green. Actually, you know what? He's a better witness than I thought. I apologize for what I said coming in because I remembered him being, maybe it's because we played it at a higher speed. And so it didn't he didn't really catch like the stuttering, and it maybe at regular speed he sounded a little more uncertain. But look at how nice, like he's kind, he's nice. He doesn't badmouth the other two experts. And this sidebar goes on for quite a while.
Opinion.
But
Okay.
why were those objections sustained?
I don't know. Let's hear how he rephrases the question because
Yeah.
we never know what happens at sidebar, right?
Right.
So let's
Yep.
hear. Sometimes we can tell by the way he
Deduce
is
from
forced to
it, yeah.
rephrase it.
Do you have an opinion as to the timing of that first search for Haslam to Diane Cole?
Yes, I do.
So the only thing that he took out from that sentence was, do you have an opinion with a reasonable degree of scientific certainty? Do you have an
Oh my
opinion? And then he
God.
says, yes. And then he says, what is the basis for your opinion? Instead of, do you remember how she made,
Which is
when
crazy,
she did the
'cause,
voir
that
dire
was her
of Dr.
whole
Russell
problem.
during the first trial?
Right.
And she's
Yeah,
like,
her whole
well, you
problem
didn't
with
say the
her-
magic words of reasonable degree of medical certainty. So, I really don't know if you even know what you're talking about. And then when the question is asked properly, it's like Twilight Zone stuff.
What is that opinion?
Crazy.
That would have happened at or before January 29, 2022 at 2:27:40 a.m. in the morning.
And what is the basis for your opinion?
Again, by how this particular phone operates with that exact operating system and comparing to other data on that phone and the way it presented it out itself is all consistent with that search happening at or before that time.
Mhm.
And what opinions or conclusions did you reach regarding how, if any, how the 2:27 a.m.
Any.
search was deleted?
Well, we know that that's in a deleted state. And importantly on that phone is when I say, I keep using the proverbial we, I found a lot of other that would have been used or deleted artifacts between midnight and the early mornings on January 29th, 2022.
Okay. Are you aware of any internal mechanisms that could have caused that deletion?
No, not in this particular case. I know of no mechanism that would have done that.
All right. And you mentioned other deletions on the phone. I want to show you what has been marked, if I may approach. Sure. MMM for identification.
Yep. Okay, this is from Cellbrite. It is a program, again, like the Axiom that processes data. And this is this lists out a 623. This lists out a deleted call record.
Deleted calls too.
Are you able to see from that record to whom the call was placed?
Yeah, well, we have the number, and I won't necessarily read it out loud here, but through searching, and this is from the phone of Jennifer McCabe,
Yep.
But through searching for that, the number, I was able to see that it went to, you want me to say the name?
Sure.
Yep. Uncle Brian
Uncle
A.
Brian A.
I would offer that into evidence, Your Honor.
Same objection as before, Your Honor. As when this was, may we approach?
See, another objection. They don't want to show that the Uncle Brian A. Was it the screenshot he was talking about? Our phone call was deleted. They have another sidebar.
Yeah, so she screenshotted his contact information and later deleted the screenshot.
Exhibit numbers, it looks, so folks, we're trying to streamline the exhibit number.
She also
so-
deleted the call she also deleted that call,
Right.
you know.
And I remember why they
along with
objected,
others.
because this is already in evidence. It's already in evidence. So here's that's what happens here.
Numbers, it looks like, wanted to keep it with that, and is the next exhibit. So
she says-
far removed from where it was, that this will just come in as the next exhibit. So you will technically
It's already been admitted, so they had to admit it again because they're so fakakta in their
have it in
exhibit numbering.
Thank you. May I approach again, Your Honor? Document before you, if you can identify that for the jury, please.
Yes, this is another report generated out of Cellbrite. It's based on Ms. McCabe's cell phone data. And this lists out the call log with a number of deleted items and number of live items.
I would offer that, Your Honor.
If I get to see.
Sure.
It's fine, Your Honor. I think it's already in evidence as well, but
So
Actually, it's, I confirmed it's not. It's not yet in evidence. We looked at the exhibits that were specified, so
they're
thank you. If you could hand that to the witness, and if I could have first page of that exhibit displayed.
Okay, now they're going to go through everything that she deleted.
Okay, with regard to that exhibit, Mr. Green, what did you find that was unusual, if anything?
objection.
sustained. Ask it differently.
Really?
Mr. Unanimous.
Yes. What did you find
Unusual.
of note?
Okay.
Of note.
Certainly. What was the time frame of the deleted records? Now, I'll just talk about this particular report here. It starts at 5:33:47 in the morning, and on the second page we see it ends at 8:50 and 15 seconds. Again, a.m. And then the normal calls, what we would call live data, then begins at 8:59 and 34 seconds and goes on throughout the day with no additional deletions.
And what else was
Am I
happening
right that those are
at
all-
this
that's
time?
call
Say again.
what else was happening at this time?
What is the time from when
Jen,
to when? Yeah, go ahead. Tell us.
so basically it shows that Jen McCabe between 8:50, whatever the exact timestamp is, but approximately 8:50 and like 8:59 or something, right before 9 a.m., deletes a bunch of her call log, right? She deletes all these calls from the time in question, and that early morning hours. And that is right before she called Lank back to the scene to conveniently convey all these incriminating claims about Karen
That's
Reed.
right.
Oh, I forgot to tell the 4 or 5, however many police officers from CPD that I spoke with at the scene. I forgot to tell you guys all these damning things that happened now that I've spoken with my family inside and had a family meeting, and I
Right.
just scrubbed all of my incriminating communications. And Lank, she calls him back at around 9 a.m. and he comes back to the house, and he records down Jen McCabe's claims that, Karen Reed was what was she saying? Like, I think that's when she claims she was asking if she hit him, um, mentions the tail light,
Well, I've got the receipt right here. And here it is. This is
Lank's
the
report.
original Canton PD report.
There you go.
And this is Michael Lank's
When the
statement.
cover up begins.
His report, Michael Lank's report. And again, this was on January 29th, 2022. In the final paragraph of Lank's report, he says, paragraph 8, at approximately 9 a.m., I was contacted at the police station by McCabe, Jennifer. She asked if it was possible to come back to 34 Fairview Road and speak with her. Lieutenant Gallagher and I both immediately left and arrived back at 34 Fairview within a few moments. McCabe told us that she recalled something that she was not sure if we were aware of. She said that when Reed was driving around with her and Roberts looking for the victim, she said something to the effect of, "I hope I didn't hit him." McCabe told us that she made these statements again at the scene when the victim was discovered. She thought that Reed may have made these statements in front of a police officer, but she was not sure.
I mean, everything about the wording of that. She thought that Reed may have made these statements in front of a police officer, but was not sure. It's like that is just damning.
Yep. And remember, she had spoken to several other officers at the scene. I don't have time to do this today, but she had spoken to several other officers before Lank that morning. She
Right.
spoke with Saraf. She spoke with Good, I think.
Yeah, Lank didn't even arrive until I think around 6:24 a.m., the time that she's making her cover up Google searches.
Right. And all of the inconsistencies in her statements. And that's something that I wanted to do another day. So we will do that another day. But you're
And
right.
why did
I just wanted
Lank
to
even
give you the
come?
receipt on that one.
He wasn't even on the schedule. He wasn't even supposed to be working.
No,
But
of course not. But call him at the station and tell him to come back, and he runs right over to let you add stuff. So that's the bottom line, is that she deleted a whole bunch of stuff right before 9 a.m. Then it was this
Now 3 seconds 15 with
Phone calls.
tell my kids to go to the movies to see the Bob Dylan movie. So I gotta.
at the earlier time. My dad.
I heard it's really good. What happened here?
Take this down for a minute, please. I have to see counsel.
See, this time she just.
Calls were found deleted.
Earlier time in
What percentage of phone calls were deleted? Okay, that's what he asked.
live data after the 8:59:34.
What percentage of phone calls were found deleted on Jennifer McCabe's phone prior to 8:50 a.m. on January 29th?
So all right, I have to see you. Take this down for a minute, please.
There's not even an objection.
I have to.
There's not even an objection. She's like, take this down. I have to see you here. There's not even an objection. That's like a sua sponte.
I'm
break.
sorry. She's just insufferable.
It's mind numbing.
I didn't miss listening
Deleted on
to
Jen McCabe.
Bev.
And then they do let him ask something here. Hold on.
So, Mr. Green, I'm not sure if that question was clear or if you understood it. If it's not, please let me know. But I had asked you from the first recorded call there that was listed as deleted until 8:50 a.m. or so. what percentage of calls were deleted on Jen McCabe's phone within that time period?
Yeah, so we found no live data, so 100% of them would have been deleted.
100%.
Now, are you aware of the term spontaneous deletion?
No, sir. I know
So
what
that also,
individual words mean, but in relation.
Yep.
that also, the you know, a lot of people on the other side, or whatever you want to call it, say that Jen didn't delete anything off of her phone. All those things that were deleted were just deleted because she made so many calls before turning her phone over that her log had already, you know, purged the old records from the database. But actually, Ian Whiffen Ian Whiffen debunks, if you will. He
Yes.
debunks that actually. They didn't even ask Ian Whiffen to look at that, but they did ask him about the Knowledge C database, which he confirms doesn't start purging data or records until on average minimum 2 to 3 months after the fact. And Jen McCabe's phone extraction was done on February 2nd of 2022. So that's like a week within a week, you know. It's not that
4 days,
the
yeah.
concept that the deletions were auto deletions or that they were just purged automatically from the database is inconceivable, because that's not how the Knowledge C database works. But also the fact that all of the records were deleted at the same time, you know, this during this time period right before Lank comes back to the house, that's also really problematic, because the way that records are purged is they're purged on a one by one basis. So, you know, if your phone log gets exhausted, or, you know, fills up to whatever the capacity is, it's like a first in first out basis. It's
Right.
not going to clear all, you know, all however many hundreds of whatever calls that are in the log at
Mhm.
one time, at one, you know, point in time.
Right. Yeah, this needs to be hammered down better, I think, next time. It's too hard for the average layperson to grasp the gravity of it, I
Yeah.
think.
Relation to digital forensics, I'm not familiar with that term.
Spontaneous
Do you
deletion.
have an opinion as to how those calls would have been deleted from that phone?
Those would have been user deleted.
User deleted.
I may have a moment.
Mhm.
Sure.
And there's that. User deleted. And then Lally gets up for a less than stellar
Which
cross.
is also corroborated by Celebrite.
Right. That it's user deleted.
So are we also going to argue now that Celebrite also has it? Is it just a coincidence that Celebrite has this other fluke in its software, in its tool, that makes it incorrectly interpret data surrounding user deletions or deletion of data, period? I mean, if they can't accurately decipher how data is altered or deleted, whether it's auto deleted, user deleted, then what good is the, you know, exponential number of times Celebrite has been used for that purpose to show consciousness of guilt?
Right. User deleted. That is the mechanism. No wonder they want to keep his testimony out. It sinks her. Now that we go back and listen to it. Johnny Popcorn, thanks for the $100 super chat. You ladies are the goats. The defense better bring their A game next trial. They got a D+ in the first trial. Frankly, they stunk. Hopefully that was with
Oh my
purpose.
God.
And Melanie, I've always been here. I don't have the time or attention span for the chat, though. Oh, thank you, Johnny Popcorn. I appreciate you so much. You're amazing. Mick
Great
gifted
name.
10 memberships. Yeah, Johnny Popcorn. Thank you. Cat Artist, what does the Commonwealth gain to find Karen Reed guilty? I think they keep their credibility. Thanks, Cat Artist. Any other thoughts on
Well, what
that?
do they gain to find Karen Reed guilty? I mean, the defense has, the defense, you know, don't get me wrong, they've levied some pretty bold accusations. They've essentially, for the defense theory to be correct, that means there's a lot of corruption by the Commonwealth, by the DA's office, by DA Michael Morrissey.
Mhm.
DA Michael Morrissey has every reason to get a conviction, to get Karen Reed to be found guilty, because you know, from his perspective, he believes if he achieves that, that it absolves him of all of, you know, the claims that have been levied. And but the problem is that the people, we're watching what has been going on, and it's not even that the defense has to levy any claims. We've seen the Commonwealth's own actions. We've seen how they withheld and walked back discover, like they refused to turn over discovery for 2.5 years. I mean, does Rule 14 not apply to them?
No, doesn't. There's like selective enforcement of rules and laws, and you see it. Witness
So, you
intimidation,
know,
littering.
I think I would argue not only does DA Michael Morrissey, but even
Keeps himself out of trouble.
Judge Cannoni has personal stake in the outcome of this trial, because she also has been by the public heavily scrutinized, right? You know, I mean, her reputation has been called into question, and I think that these people feel that if Karen Reed is found guilty, it exonerates them, it absolves them.
It's vindication for them. 100%. Takes the focus off of them.
Mm-hmm.
I think Brendan's regret. Thank you for the 50 so much. Surely Auntie Bev can clearly see this could have serious ramifications to other cases that have used cell data to convince others, or to convict others. This is very dangerous if she allows this. Hank is spinning wheels to defend the McAlberts. This is crazy. I'm not sure if I already addressed this one or not, but thank you again for that.
Great point.
And this one I did. Why is Jen being protected? Yeah, I got it. Oh, thank you. Thanks, Hate Corruption. Awesome to spend New Year's Eve with you too. Commonwealth has no shame, says Intolerant. Sweet Lou became a member. Thank you so much. Don't be hating. Thanks for the 5. FBI and Celebrite shows this happened at 227. So Brendan wants to exclude exculpatory information. Isn't that a violation of Karen Reed's rights? I want to talk about with you. I'll put a pin in that because I wanted to talk to you about that also. The FBI expert who found 227. So just hold that for a second while I go through the rest of these.
Sure.
Colorado Mama 23. Thanks for the 10. Can you refresh our memory why the dog bite expert you had on can't be used at trial? He was amazing. He's a certified trainer, prior law enforcement. I didn't say he couldn't I didn't say he couldn't be used at trial. I said he couldn't be used as a medical witness to opine about the medical cause of the injuries. Whether or not, based on what they've exchanged lately with their dog behavioral expert, I don't see why he wouldn't be able to testify at trial, but we'll see about that. But in the beginning, I don't know what his experience is as far as prior testimony. I don't know if he's ever been qualified as an expert to testify in other states. And that always is a consideration when you're looking at a Daubert hearing, right? So thank you so much for the 10. Marie gifted a membership. Thank you, Marie. FBI and Vanity Fair agreed with Green. Hanky, pack it up. We'll get to that in a second. Life of Deshy. Thank you. Cat Artist. We did that. Stephanie said, happy and healthy New Year to you too, Stephanie. Sent me a little something on Venmo. Thank you very much for that. And $100 is not a little more than something, Stephanie. So thank you so much. Happy New Year to you. Sherry, thanks for the 50 on Venmo. Thanks for all I do. Love your show. Love you too. And Sherry as well. Happy New Year. I, along with so many people, thank you so much for your countless hours. Oh, I thank you so very much as well. So Olivia, I'm just going to run for a second so I can change so I can get to the movies. And if you could catch everybody up on what your thoughts are on the FBI expert and whether the FBI expert who confirmed that 227 happened, maybe that FBI expert is watching and maybe they can come forward and actually, testify in the second trial. Go for it. I'll be right back.
Well, yeah, it's a good point. I mean, hopefully what comes from this is the defense really pushes to be able to bring in that federal expert who, just as a reminder for everybody, we know from the pretrial hearings, once the Commonwealth and the defense got the TUI evidence from the feds, that evidence confirmed that a Quantico-trained special agent with the FBI's Regional Computer Forensics Lab specifically confirmed that the search "Hoss-Long to Die in Cold" was made on Jen McCabe's phone, and it was made at or before 2:27:40 a.m. on January 29th, 2022. And as Melanie Melanie and I discussed on the last show I was on a few days ago, one of the reasons why I put more faith in the FBI's experts determination as it relates to the 2:27 a.m. Google search is because, unlike Ian Whiffen or Jessica Hyde, for instance, the feds, they don't really, as we know from looking at other federal investigations, they don't really have limitations as it relates to what evidence, what data, what records they can look at and can pull in their investigation. In this case, if you look at the procedural history and just the investigation, the Commonwealth has been steadfast about opposing all requests from the defense for more records, for more evidence, like the Google geofence, and even like Jen McCabe's cell phone records. The Commonwealth steadfastly fought that request and opposed it. And with the federal expert, the FBI Quantico trained special agent in digital forensics, I imagine that they also looked at other data sources. I imagine they probably looked at Jen McCabe's iCloud data, even potentially her Wi-Fi data, the Google geofence data. It's like, if this is such a factual dispute that the Commonwealth is so confident in, why haven't they subpoenaed Google? Why haven't they
Right.
subpoenaed Google for Jen McCabe's phone data, for her Google search history?
They won't do it.
They've
And they
had
know that the judge
they've
won't
had
allow the
almost
defense to do it.
3 years to do that, and instead of doing that, they've gone out and paid expert witnesses to essentially defend Jen McCabe or muddy the waters. I mean, I can think of a great way to settle that factual dispute, and it would be going straight to the source, Google.
Right.
Yet they actually opposed when the defense, or no, they didn't oppose, but they made no effort to retrieve Google geofence, and they did everything to sabotage the ability to ever get that evidence, which I find hard to believe they would do that if they believed it would help their case.
And isn't it ironic, don't you think, that here we are now and they're just trying to exclude Richard Green's testimony only with regard to Jen McCabe? That's what blows my mind. So, okay, so everything else that Richard Green testified about, John O'Keefe's Apple Health data, we're going to allow all that. We just want everything out regarding Jen McCabe. And it almost seems like, if you're looking at this from, a crazy person point of view, they've been giving marching orders to get Jen McCabe out of this somehow, right? I mean,
Well, yeah, I mean, you remember, Michael, that the Bedrow letters, we recently learned that Michael Morrissey, I mean, seems to be very, very protective of Jen McCabe, who should otherwise be some random, in his life at least, random, irrelevant witness who
Right.
he doesn't know and has no affinity to.
Right.
But he's sending these personal emails on a personal email account, so as to hide the fact that he's sending the email, to do some favors, trying to get these judges and court officials to bend to his will, essentially. I mean, he's sending these I don't know how you can't perceive it as threatening or intimidating email from Michael Morrissey, because he doesn't like the decision that the judges came to, and because Jen McCabe texted him and she was shocked and horrified.
Yeah, right. I can't believe you didn't get it. For those of you who did not watch the pretrial stuff, I suggest that you do go back and watch it, because you're going to learn a lot more. I'm looking at my playlists alone, and I've got 36 videos on post-trial stuff Then there are something like, I don't know, I have so many playlists here, I can't even find them right now. Let's see. There's at least 60, I think, from the trial. And there's a whole bunch of, we did all the pretrial stuff too. So if you're not up to speed on that, I suggest that it would be a really great watch for you to go and revisit all of the pretrial hearings, all of the pretrial motions, all of the motions in Lemonade, because we went over all of that stuff. Yeah, there's 25 videos on pretrial hearings. Most of them are 3 hours long. That's like 75 hours right there. There's 63 trial live streams, and we're up to, I think, 36 post-trial. So there's plenty of information for those of you who don't know every single detail about this case, the way that Olivia does. And apparently I do as well. So thank you all so much for coming. Olivia, thank you so much for spending so much time with me again today. I appreciate you so much.
Thanks for having me.
Thank you for coming. Everyone say goodbye to Olivia, and thank you to Olivia. And hopefully we can do this again really soon.
Yeah.
All right. Any closing thoughts before I run off here?
Too many to express in this short amount of time.
I know. I feel like we need 3 hours at a time just to do a chunk of this. You know what? When the defense opposes this, which we know they will, maybe we can come back and do that. And tune in next Tuesday. If the first thing to happen is next Tuesday, Dr. Russell's coming back for the rest of her Daubert hearing.
Wow, that was quick, wasn't it?
I know, it went by so fast, right? I can't believe it's 2025 already. Thank you. Thanks, moderators, for keeping it classy today. As always, this is a very difficult topic to cover because the trolls are out in full force, and we know they're always watching because they'll go and attack us on Twitter as soon as this is over, right, Olivia? I'm not on Twitter, so anybody out there who wants to come and go and defend us, feel free. We love it. We love our defenders. You guys are amazing. Moderators are great. Stay cool, stay kind, stay classy. Smash the like on your way out, even if you're hate watching. Comment respectfully. Be nice to each other. And as always, peace. We'll see you real soon. Thanks, Olivia. Good night, everyone.